Ladies and gentlemen, good morning. We kindly ask you to take your seats and keep your phones in silent mode. Welcome to the seventh conference for children in digital environments event hosted by the Superior Court of Justice and promoted by the Ibero-American Center for Childhood Rights in partnership with the Law School of the Federal University of Rio Grande do Sul. The conference has the support of the National School of Training and Perfectioning of Magistrate of Alana Institute, the postgrad program in law for the Federal University of Sergipe, the Ministry of Human Rights and Citizenship, International Association of Judges for Youth and Family, the United Nations Development Program, and the Coordination for Training of Higher Level Personnel CAPS. This event will be transmitted by the YouTube channel except for the presentations of the working groups that will be done at the end of the day. The participants will receive a certificate upon registration of attendance, which may only be completed in the afternoon at the reception of this hall for the ones registered for in-person participants or by the link available at YouTube platform for the virtual participants. The certificate will be available through the Educa Inform system 5 days after the closure of the event. We inform you that during the whole event, we'll have simultaneous translations for English, Spanish, and Portuguese. The devices can be retrieved at the reception of this hall. In this event, we suggest the use of audio description voluntarily as a resource for participants and accessibility for visual deficiencies. I am Valdir Borges. I am 190 meters high. I'm bald. I'm wearing a blue suit, a pink tie, a white shirt. Ladies and gentlemen, for the opening panel of the 7th Ibero-American Conference for the Rights of Children and Violence in Digital Surroundings, Her Excellency is the Director of the Federal University of Rio Grande do Sul, Professor Dr. Ana Paula Mota Costa. Also, Ms. Executive Secretary of the Ministry of Human Rights and Citizenship, Janine Melo. The Director for Ibero-America of the Ibero-American Center for the Rights of Childhood, Dr. Sofia Cobo. Ms. Vice President of the Committee of Rights for Children and the Organization of the United Nations, Dr. Mary Beloff. Also, Mr. Miguel Solero, President of SIDENI. Ms. Legal Coordinator of the Alana Institute, Dr. Ana Claudia Cefali, and also Mr. National Secretary for Digital Rights of the Ministry of Justice and Public Security, Dr. Victor Oliveira Fernandes. And right now we ask everyone to kindly stand so we have a minute of silence in tribute to Professor Dr. Johannes Doll, Professor and former Director of the Faculty of Education at the Federal University of the State of Rio Grande do Sul that passed last Saturday. We may take our seats. Right now, the Director of the Law School of the Federal University of the State of Rio Grande do Sul, Professor Dr. Ana Paula Mota Costa, has the floor. Good morning, everyone here with us. It's a great honor to be coordinating and hosting this event at the Superior Court of Justice. I'd like to begin by my audio description. I'm a white woman with brown hair. I'm wearing a green dress. And anyhow, I am mid height. I'm 169 inches high. And that's my description. I would like to greet the authorities at the panel, especially Dr. Miguel Cirillo, President of the Ibero-American Center of Rights of Childhood, Dr. Janile Melo, Executive Secretary of the Ministry of Human Rights and Citizenship, here representing Minister Macare Evaristo, Dr. Sofia Cobo, my companion in organizing this event, who is the director for Ibero-America of the Ibero-American Center for the Rights of Children, friend Dr. Mari Beloff, who is our keynote speaker and professor from the University of Buenos Aires, and also vice president of the Committee for the Rights of Children of the United Nations. Dr. Ana Claudia Cifoli, also a colleague, organizer of this event, a collaborator with the legal coordinator of Alana, Dr. Victor Oliveira, that honors us with his presence, National Secretary of Digital Rights from the Ministry of Justice and Public Security. I'd like to greet especially Dr. Maria Paula, who was here, who was very helpful and a good companion organizing this event, on behalf of who I greet all the team at the Superior Court of Justice and Dr. Herman Benjamin, Justice, a great colleague and joining companion for holding this event with us. If it weren't for Dr. Maria Paula and her team, we wouldn't be here. So I thank you very much. I thank her very much. I'd like to say, like Justice Herman Benjamin said, it's the first time that in the Superior Court of Justice, Court of Citizenship, we have an event dealing with the rights of children and teenagers. For all of us who are from the rights of children and teenagers, who try to ensure these rights for many years, many colleagues here from many countries also are like me, walking this path. It's a reason for a lot of pride and honor and thankfulness. It's very rare that we have the availability of doing an event with this topic, trying to look for interpretation according to the Convention of Children and Teenagers in the many ways of violation we experience. So it's very important that the court thinks about this. If that for itself would be enough, but it's very important also by the conjuncture we are experiencing. Less than a month ago, we passed a law, the digital statute of children and teenagers, one of the first legislations in the world that works in the sense of protecting the rights of children and teenagers in digital environments. Today, and a space of violation of rights also. We hope that with this reflection here at the Superior Court of Justice, we may develop support for the national interpretation of this legislation by judges, prosecutors, public defenders that are here with us or virtually, that can prestigious and in these 2 days of event of major technical quality, be able to better interpret or properly interpret that legislation, developing a culture of jurisprudence, interpretation that's good for the whole country. That's very important. Same ways, it's very important to have this possibility of communicating with the many countries here. We have many works that will be presented to the academic committee, then were selected and will be presented in the working groups in the afternoon. Academic works from people from Brazil and abroad. We have here with us participants from many countries also, and all this is very rich in the sense of providing a possibility for this legislation to be good for these countries and provide a contribution and subsidy in the contribution that will happen in each country. And the experiences exchange with Brazil is very important also because we have a possibility for we have different cultures, and they may exchange experiences regarding the freedom and protection that is more important in each country, the presence of the parents in protection, the accountability of companies, the state, all that will be under discussion. So I'm sure it will be a very fruitful event for all of us. I'd also wanted to take the opportunity to thank my whole team from the Federal University of Rio Grande do Sul, students and research group that collaborated daily for this event to happen. And using a last second of my time, explain to you that this tribute to Professor Johannes Dahl is important for us also, as well as for the Superior Court of Justice, because he was here recently. He was also a defender of human rights, especially the human rights for elderly populations, and left us abruptly last Saturday. That's thus this tribute that touches all of us at the Federal University of Rio Grande do Sul very much. Thank you very much, and I wish us all an excellent event. Thank you very much. Right now, Ms. Executive Secretary of the Ministry of Human Rights and Citizenship, Janine Melo, has the floor. Good morning, everyone. I'll begin by my audio description. I'm a white woman with hair on my chin, on my shoulders, brown hair. I have 1 meter 60 height. I'm dressing a beige shirt, a black skirt, and a black high heel shoes. I'm very happy to be here. I wear glasses, an important feature of my in my audio description. First, I'm very happy. I'd like to thank for the opportunity of being here in the opening panel and knowing our ministry will participate in the discussion during the next 2 days with the other organizations here with us. I think we are experiencing a very joyful moment regarding the advancements we achieved in Brazil, especially over the last week. After the 17th, we'll have the opportunity here, the Ministry of Human Rights, Ministry of Justice, right winger, to bring these issues here. I'd like to greet my colleagues in the panel, especially on behalf of Mary, who is our representative at the UN Council for Rights of Children. So I'll try to bring some issues that are important for us from the symbolic point of view regarding these advancements. I'll ask permission to read and not leave anything out because my time is short. Well, we are in an era where access to internet occurs more earlier and earlier, amplifying horizons of learning, convival of our children and teenagers, but exposing them to risks that can't be ignored. In that context, initiatives like this seminar become essential to promote dialogues with accountability and joint action between states and societies. Between the challenges that mobilized Brazil recently, we highlight the concern with adultization of children and teenagers in the digital environment. It's a phenomenon that has repercussions not only in the digital environment, in real life also, in our daily lives, with actions regarding protection of children and teenagers and non-violation of children and teenagers that commits healthy development, dignity, and rights to childhood. Data from the census of 2022 from IBGE pointed us that Brazil has about 34,000 children and teenagers between 10 and 14 years of age that experience in some kind of marital situation. And we reiterate that with the approbation of the bill of law passed by Congress, that there's no possibility for relativation of rape of vulnerable. So this brings repercussions in the digital environment and how this is present in our daily real lives. These figures reveal that child adultization is not an isolated phenomenon. It's connected to inequalities that are structural in a broader context of violence added to the rates of violence against women in Brazil. So it was from that social mobilization and institutional mobilization around protection of childhood that was possible to advance in the more firm responses from the Brazilian state. Exactly a week ago, the digital ECA came into action, historical milestone in protection of children, considering the challenges in virtual world. And between the main advancements, we have measures of accountability of platforms in the prevention of risks and damages, security measures that have to begin since the conception of the services till the fitting the services to the age, to the ages and harmful content. The law affects practices regarding adultization, exploitation of children and teenagers by forbidding monetization and driving of contents that treat them erotically or suggestively, and also the obligation of removal and communication to competent authorities of contents that include to sexual violence and other kinds of violence. And the 17th, last week, our president signed 3 decrees. One of them regulates the law, so defines the guidelines for implementation of this law, so it's an effective measure in Brazil. Beyond this, we created the National Center for Protection to Children and Teenagers, connected to the federal police, that will have the attribution of centralizing the reports of digital crimes, and a 3rd decree that structured the National Agency for Data Protection, which will be the responsible party to enforce new legislation. So Brazil advances in a legal framework, administrative legal framework, to help implement the law effectively and long-lastingly. And Brazil aligns itself to an international concern consolidated in Common 25 of the UN, establishing the parameters for communication of children in digital environment. That's why this conference represents a valuable opportunity of going deeper into this debate and strengthen cooperation between our countries. We're here trying to add efforts for the development of a safer, more ethical digital environment, promoting the environment for our children and teenagers. But more than ever, we want to reinforce multilateralism, dialogue between countries to ensure the future of children and teenagers. The challenges are shared. That's why the solutions must also be developed collectively. And it's with that common commitment sense that we guide ourselves developing policies, digital environments, and promoting a more dignifying, promising future. I'd like to greet everyone here who will participate in the discussion during these 2 days, and may we recognize our decisive actions from each one in the development of this agenda and the assurance of a better future for our youth and childhood. Thank you.
At this moment, the floor, we have the Director of Ibero-American for the Rights of Children, Dr. Sofia Cobo. Hello, good morning. I am going to describe myself. I have a shirt with black stripes. I'd also like to express that I'm very happy to be present here today with all of you in this forum, and also to be able to have the participation of all of you here and the ones that are following us here on site and also virtually. So the Ibero-American Center for the Rights of Children is an initiative that was created in 2018 with the objective of generating this meeting, a space for meeting and development of people that are researchers and investigators, teachers that are interested in the protection of rights of children and in the region. With 8 years of its inception, we developed 4 strategic axes, which is the generation of knowledge, technical help, and public policies materials. And in this axis, to help expand the knowledge, we had up to this date 3 Ibero-American conferences for the rights of children, and today we're now on the 7th conference. So all the themes here are related regarding juvenile justice and individualization of penal accusations during teens, and also liberty, issues. All these themes are now being followed up and are of investigations and publications that are specialized in this field. The seventh conference, which is starting today, is the result of the new lines of investigation that are connected to the rights of children in terms of the digital environment, which we also had a report that was published, and we will be able to showcase here, where we had observation of number 25, where now we have 5. And the main objective of this seventh conference here is to generate an academic talk and also technical talk in regards to the challenges and opportunities that are presented in terms of the digital environment, that way guaranteeing the rights of women, of girls and teens, focusing on violences and the established principles. More importantly, number 25, the Committee of the Rights of Child. And for the next 2 days, 30 people who are going to have presenting their expositions here. We had more than 50 plus academics and 8 countries in the region who will be showcasing themes about public policies, jurisdiction, and digital environments in terms of children and adolescents. All of this is going to be developed in 2 conferences with 3 discussion panels and 3 discussions that are informative, specialized presentations, and showcasing academic reports in a hybrid approach in which we will be able to work with 700 people that will be part of this event. I'd like to thank the Superior Court of Justice of Brazil to be our host, and also the Rio Grande do Sul School of Law for its leadership, and all the institutes that have been helpful to make sure that the seventh conference was put into place. I have no doubts that the analysis and the thoughts that we're going to present here are going to be seen positively and will have a great impact in the lives of our teens, but also their families and their communities. So thank you very much, all of you, and I wish you all an excellent journey today. Thank you. Well, we're going to hear the Organization of the United Nations, Mary Beloff. Hello, I speak Spanish. In respect of Portuguese, I think Portuñol is not a good idea. So I'd like to say that I only speak Portuñol in very extreme situations. So I'm going to continue speaking Spanish. I didn't even know that I was going to speak here today. But what I'm going to do here is actually say thank you for all of you to make sure we have more time in this conference. So I'd just like to highlight 2 things that we all know that we are gathered here today, and I'm very happy and grateful for this invitation. And I also know that I need to give a description of myself. It's a little bit difficult for me, but I can say that my hair is not very on point, which is a characteristic of mine. I wear a blazer, and that's my self-description, auto description. I was a little bit wrong with the temperature, so that's why I'm wearing a blazer, and it's all the color is a little bit of wine burgundy color. I'd like to especially thank my colleagues and the university, the Professor Paula Mota, for this invitation to be a part of this conference. And I think these are the profiles and descriptions that I need to bring to the table, and the institutional themes that we can bring that can help us bring an invitation to certain events and circumstances. But I'd like to showcase that I am an academic, and everything that I've done is thankful to the public university of my country. I am a magistrate professor, and I'm here sitting to you all, not representing the committee, but clearly for the opportunities and circumstances. I am integrated here with this group to help give a general perspective, because I know that more beyond the glamour and international topics, Ana Paula has invited me because she respects me. And I can say this freely, that I do the same. So I'd like to thank the organization, because I believe that everything that's beautiful about this institutional organization. I had the chance of getting to know, to be a member of the committee. I didn't know my colleague to the right, and now I do, and her work here is exceptional and very helpful to be able to develop this here with you all. I'd also would like to mention that I did read the doctoral thesis of Doutora Elizabeth Henriques, and I really did think, oh my God, this is a very advanced thesis about digital environments. So I had to review certain points, and I could see there's a lot of correlations between these themes that we don't see in other parts of Latin America. So I can say to you all, it's because of this purpose that I'm here. And I say this humbly, this knowledge that we have acquired about this theme is very vast. And I would also like to say it's a little bit difficult for me to feel that I can contribute to this conversation because you're all more advanced in many years. So in that way, I'd like to say my thanks, conclude my presentation, and to also say that this organization and all the ones here who made it happen, you have a person in the organization that I worked with her for many years, which is Dr. Miguel, which is here also in our table. It's been a long time since I haven't seen him, so I'm very happy to see him today. And I'd like to say thank you for putting me here, Professor Posato, all our friends that we've been reuniting here, talking about old topics, because we know that when talking about law and rights, it's a very ancient topic. The moment that we start thinking about our children and thinking about technology and their rights, and we also still have a lot to learn and to relate with one another. So thank you so much for the Superior Court of Justice. Whenever I feel that I'm part of Superior Court, I'm very thankful. Thank you. Now we're going to have the president of SIDENI, Miguel Silbero. Good morning. I'm a man. I have 1 meter and 70 centimeters. I am wearing a blue suit with a blue tie. I think that's my auto description. So for me, it's an honor to be here. I didn't know that I was going to speak, but I'm going to say some brief words. I'd like to extend my gratitude for the Superior Court of Justice, the University of Rio Grande do Sul for being a partnership in this initiative that happened with basically a decision with a group of academics that we are part of. And 6 years ago, we started exploring a new world where law has a lot of challenges, more specifically, the rights of children and teenagers. And one of them is the digital world. We started with small investigations during the pandemic, and then we started revising certain breaches of certain countries in Latin America where there were children, boys and girls in digital mediums. And after that, we started seeing the strengthening of the educational system with the partnership with CISLO. And we saw the possibility of doing an investigation, a compared investigation that we're going to show here today. But I'd like to first greet you all as academic group in a space that was designed for many people that have a long trajectory of human rights, more specifically the rights of children and teens, where we will be able to explore with universities and other instances in the academic world, and also investigations with new themes and strengthen the respect and the protection of the children and teenagers of Ibero-American. So we're thinking about our languages. We speak Portuguese, we speak Spanish, but we're also bringing to the table judicial sciences based on the language that we speak, obviously, but also to be aware of the digital transformation. And we believe that effectively we're going to have a very specific task to develop this in the Ibero-American world, which is a doctrine that is well known and a protective doctrine that can bring all the rights and protective rights of the children and teens. So it's an honor to be here today again in Brasilia, excuse me, in Brazil. I was here once, but I can see now that Brazil has taken a giant step since the time I was here, we had the anticipation of the rights of the children and teenagers, which was a light in the end of a tunnel with all of us that thought about the development of the Convention of Rights of Latin American for Children and Teens. So with this statute, in digital environments. So I'm going to stay here till the end for our closing remarks, but I hope that everything is very interesting and that our conclusions of these conference is part of a process that's bigger than us. So I hope we can actually reach these higher standards, more specifically for the rights of children and teens in digital environments. And may this be present in our next committee for Ibero-American for Spain, where we're going to try to bring the conclusions of this conference here today and the experiences of these communities that we thought of to better improve the lives of teenagers and kids, but obviously in regards to digital environments. Thank you. Now we're going to listen Doutora Ana Cláudia of Instituto Alana. Good morning. I am a woman. I have 1 meter and 70 height. I am white. I am wearing a t-shirt and a pants with details in brown with blue. My hair is up and my eyes are brown. It's a great honor to be here today representing the Alana Institute with our partners. So I'm very happy to all that helped the organization in this event. And also in the name of Savia Kobo and Nusideni, I'm very glad I finally was able to meet you in person. Professora Ana Paula Mota Costa, which is a mentor and an inspiration for me for a long time, and Doutora Maria Paula, who was helpful in making sure this event came to place. Dr. Hector Benjamin, which is a long partner. Thank you so much. It's an honor to be here in the Superior Court of Justice. This event was thought very carefully, and we hope that all of you can profit from the knowledge that we're going to share here with our specialists today and tomorrow. We know that the internet represents and brings a lot of opportunities for our children and teens, but we also know that it offers a lot of risks that come more quickly in the digital environment, like cyberbullying, violence, trafficking, exploitation, sexual exploitation. So these are type of violence against children and teens that we need to prevent and fight as a society in and out of the screen. And as Janine mentioned here, dear Secretariat, it brings a lot of impacts that come out of the screen. So it's very important that we have this event here today so we can have a dialogue and learn more about the comment of number 25 of the UN. And also, when we had just lately the Statute of Children and Adolescents that was put into place, but also the Convention of the Rights of Children in the 90s. So once again, we just want to emphasize between the committees of the rights of children and the leadership in Latin America with this statute, which is the digital ACA, the Statute of Children and Adolescents. And we hope this event can also serve as an inspiration to all of you, specifically the ones that are online, to search for the implementation of these norms and conventions and the law of digital ECA with the rights of children in the digital environment, in the digital decisions, but also in academic thesis so that we can actually promote positive changes in the societies for these groups with priority as our constitution states. So I'd like to wish all of you an excellent conference. We left some material in the opening where we actually had the commentary of the statute, and we had very recent documents that we actually launched this Friday, where we're going to have a roundtable about this event, which is a book that talks a little bit about the elaboration and the approval of the digital ECA. So I'd like to wish a great event for everyone, and thank you for being here. At this moment, we have passed the floor to the Ministry of Justice and Security, Victor Oliveira Fernandes. Good morning to you all. I Also like to give my auto description. I am a white man with short black hair of short stature. I am wearing a blue suit with a pink tie. And I like to begin in the name and the Ministry of Justice and Safety to give my thanks to everyone that made this event possible. And my colleagues here on the table, Dr. Miguel Silero, President of CDNE for the Rights of Children, Doutora Sofia Cobo, also the professor, Doutora Ana Paula Mota Costa. And I'd also like to greet the other authorities that are here present, Doutora Janine Melo, the Ministry of Human Rights and Citizenship. I'd also like to greet Doutora Ana Paula Cefali, Legal Coordinator of Instituto Alano, and Doutora Mary Beloff, Vice Chair of the Committee of the Rights of the Child, of the Children, and of the UN. I'd also like to say this is an event that happens with a timing that's very specific for Brazil. Last week, we had a historical moment for Brazilian internet. Last Tuesday, it was put into place the digital ECA. And now, on the next day, on the 18th, Wednesday, our presidents signed 3 decrees that affect and give effectiveness and normalize this law. This signal with the signing of the decrees on the following day that the law was put into place give us a sense that the implementation of digital ECA is a priority for our government and for all of Brazil. So the digital ECA, which is the law which was approved with the National Congress last year, is a fulfillment for a digital world, which is an article that many of you already know, especially the ones that fight for the rights of children and teens, which is the article 2027 that says that it's a duty of the states and of the families to protect children and teenagers. And digital ECA, more specifically, its regulation, and I like to highlight the decree 2880, which was digitalized and edited last week by our presidents. This decree makes it concrete with an article with our federal constitution, a true sharing of the responsibilities of the digital environment. So the main message that we have with this law and this regulation is that we have a duties that need to observed by companies, by parents, that will have now a new opportunity with technologies, with parental supervision and blocking and restrictions and control of content, have a new way of controlling what their children have access to in social media. And starting with this decree and law, Brazil puts itself into place as a global reference in regards to legislation of the protection of children and teens. And all the solutions have shown us that the solution adopted by Brazil is not to withdraw or exclude the children and teens from the internet, is to actually make sure that they can grow with safety, with access, with adequate content, and in respect to their autonomy and development of their infancy.
Over the next few days, we'll have many opportunities of going to specifics of all these norms, but I'd like to mention the privilege it is for the Ministry of Justice to have this space, this dialogue with the Brazilian judiciary branch and also with other jurisdictions in the development of this legal framework. Thank you very much. Thank you very much. We thank all the authorities that integrated this panel. We ask you kindly to go back to your seats reserved for you in the hall, except Dr. Ana Paula Mota Costa and also Dr. Mary Beloff. for right next have we so we can have our keynote speech. Yes, first an official picture of this moment, please, for the record.
Para a nossa conferência magna.
For our keynote speech, general comment number 25 in rights of children and digital environments. Moderator will be Dr. Professor Ana Paula Mota Costa, Director of the Law School of the University of the Federal University of Rio Grande do Sul. Good morning, everyone. Once again, I want to say it's an honor, the size of the world, to be here beside my friend, reference of so many years, Professor Mary Beloff. Mary Beloff. Professor Mary is penal law teacher in penal proceeding, teacher, professor of the Law School of the University of Buenos Aires, worked as a post-grad teacher and professor, and master's and doctorate, penal law and Mercosur law, magistrate, children, teenagers law, problems with teenagers and children. She's internationally recognized. She integrates the postgrad programs in many national and foreign universities. Her trajectory has deep academic work in criminal science and rights of children and teenagers. She integrates the Committee of the United Nations for the Rights of Children and occupies right now the position of Vice President. Beyond all, she's a major reference for many years since I, for example, began working with rights of children and teenagers in the 90s. I wrote about the history of rights of children, about childhood in Latin America, about the rights, penal rights, the perspective of youngsters, penal rights, protection of childhood or children, and other contemporaneous topics like gender issues involving children. She's our mandatory reference for the ones who want to study uh, children's rights. Dear Professor Mary, you have the floor. We are very honored and happy with you here with us. Well, once again, good morning. I will reiterate my thanks and do a disclaimer. In this occasion, that I'm here with this, I'm not representing the committee I integrate because that would require a different format. Everything I say here is as an academic, and that's why I'm free. I feel free of providing a conference like I want to, which is a scientific one. And the second disclaimer is that the technology is something, uh, I know there are many specialists in right and technology. So we are in an auditorium of the Superior Court of Justice. My analysis is not a legal analysis. It's very important from the impact point of view because we must read it and see the potentiality, the good parts, the potentiality, so it's useful for everything we need to do in this field. Lastly, like Professor Ana Paula mentioned, uh, really, I don't know if in Brazil, every time I'm in this country, I repeat this because it's impressive in the Latin America history, the contribution this country has provided to the way we translated the Convention of the Rights of Children is incomparable to any other impact of Brazilian law and the rights of the Latin American states that speak Spanish. What I call the Latin America translation of the Convention for Children is strictly a product of what happened in Brazil with the process of approval and implementation of this statute that has many consequences. And now with this new digital statute, as you call it, we will all have to learn a lot from this country. And that's why what I'm saying will be said from a place of admiration of not only by the music Brazil, but also by the Brazilian uh, legal experts, jurists. And now I'll go directly into the topic. We be at ease. I won't. Let me see. The text is completely accessible. If I would tell you now, these are the differences in the digital world. We wouldn't even need a PowerPoint. Let's look for such paragraph and such law. Well, you can do it in your phones. That's a scenario that is completely different from the scenario we had to have a date, which is a key turn was the 2019 pandemic. That's why I won't tell you or project what it says, except for specific issues, because it wouldn't be to the level of the audience and what we are going to approach this morning. Some issues that I have to explain or present to you. First of all, a topic with the name, and that's very characteristic. I refer to the Committee of the Treaty of Rights of Children, and used to observe what the committee produced, but now being part of it, I can see more clearly the problem of translation. Problems of translation in international documents, like the ones issued by this body that I integrate, are huge. I won't get into details, but I want to draw your attention because difficulties in the text have to do with translation, because with these documents are drafted in English, inclusively the documents from Latin American countries that we are trying to modify. And we all know this Italian uh, statement, traduttori, traduttori, but with some intention. It's not the same to think of a text in a language and thinking of the same in another language. And in that sense, you know, the name in English, the original name mentions environment, which connects to the following general observation issued by the committee about right to a sane environment. In Spanish, it's translated differently. Only with that, we have material to do a huge exploration regarding how we interpret the reach and content of the rights of children, how we protect the rights of children if we understand the surrounding, if we understand this environment. I just leave it as a statement, an example that there are many paragraphs in the text where we read and feel a bit strange, but maybe we follow the best reading, best interpretation, and for reasons of translation. The element of context, and someone mentioned the representative of the Ministry of Justice. I think it was the timing of the digital ECA. I'd say the timing of the general Comment 25 was produced exactly a month later or a year later. The COVID-19 pandemic, it was discussed before, but this date was not by chance. What happened at that time? what happened was each one will have his or her theory of what happened. And I shouldn't talk about this, but from the pandemic on, we had we had the use, access, and dependency of the digital surrounding was intensified by with all people, inclusively children and teenagers, in a way that was completely unknown before the pandemic. Maybe the pandemic came in a time when technology would make that possible, or others might respond to that. But in any case, it seems to me that it's indisputable that this moment is a key turn. But the most interesting thing is that not only we created we reformulated the relationship of children with technology. That seems to me happened like never before with other kinds of technologies that uh, occurred. So pay attention. This is a paradoxical issue, and for me is one of the key points we have to think of when we analyze this point from the legal point of view, which are the normative tensions that we have to solve with children and the digital surroundings. And what is that at the moment of more insulation of the history in children's lives, technology was what allowed the lack to get away from in isolation. And in that duality that I believe was mentioned by Dr. Cefali, this duality that is completely new for us is the potentiality and the threat at the same time of the digital surrounding, I mean. And it's very illustrative to see the COVID moment where this can be projected to all other contexts and children in all situations. And as now, how the document is organized, I think it's important because people here don't have expertise or in public international law, human international law. And what's a general comment? How do we make a general comment? There's a confusion. Another day we read a document that said the promise, all with best intentions, the promise we made to children 5 years ago. And I said, okay, well, I don't believe, at least uh, legally, a document and for a treaty for human children's rights and the environment is not a promise. It's a state due. It's a treaty, the Convention about the Rights of Children. Can you say in a rhetoric a promise? I don't think a promise is a treaty is a promise. I think it's a duty. It's an obligation, and it's an interpretative exercise of people that for political reasons, because to be in a committee you must be voted for. That's simple as that. For political reasons, you integrate a policy body and for the principle of majority. So you suppose you must have the conditions to be there. That's an exercise of interpretation. So the treaty, which is the main obligation, is better implemented in the countries in different situations and contexts. So it seems this is super important to have clear as a huge potentiality because, like, let's say the tool that apart from dialogues with the countries allows for when there's a concrete difficulty. It's not that there's a concrete difficulty, that we have all concrete difficulties because we know nothing about this. So the committee did very well, very timely producing this document, but we must understand what this document can provide and what is not relevant to expect from this document. There's another thing we have to consider, which is when interpreting a document, monitoring committee, when interpreting a treaty, she says, and drafting a document like this, a monitoring committee doesn't have competence or the ability to create rights. So we must be very careful because sometimes, well, narratives, the statements, the emotions may confuse things, and texts show up as creating rights, maybe things that can only be done by the states. The states can create rights and agreements, not the institutions that interpret non-jurisdictional these treaties. And lastly, I want to tell you about, because it will explain many things about how this general observation is organized and many others also, is that the difference of what happens, for example, in the international protection environments, because they're jurisdictional. I mentioned the Inter-American document, the Inter-American Court, produced by the Inter-American Court. They have two competences, one jurisdictional, another advisory, or which is similar to something mutatis mutandi, like this committee with this and the other committees with these documents. But pay attention. The advisory competence of a court like the Inter-American Court doesn't work ex officio. It works by requirement of the states and of the Inter-American system or of the institutions of the American Organization of States. Uh, there's a milestone, a guide, a question structure that models, that brings a problem and takes it to the institution that must interpret it. Uh, that has a major difference, because in the case of this committee and the committees of a monitoring committee of the United Nations, the general comments don't appear by request. So the committee interprets ex officio, to mention it legally or juridically. There are advantages and disadvantages of a body working ex officio, but as to the disadvantages, we don't know the reason for which we issue a document at a time. In this case, it was fantastic. The reality was totally changed. So the reason is clear, a new reality. Other times we don't know. But the difficulty, interpretation difficulty for me lays in the fact that the document doesn't have a milestone, doesn't have a request that motivates it, that justifies it, that frames it. So it's the institution itself that has to do an effort of self-observation, see other things that were mentioned, talk to other people, talk to whatever the experts are. The word that bothers me a little, at least it's big for me. And as a result of all this, we include the consultation with children. How many children? How many children are representing the children of the world? With which methodology? In which way? Also, that the children be heard is paramount. So there's a methodological problem that is serious. It has many sides, but for me, it's how we produce the general comments. And but in reality, what I want to say with this is that uh, we should understand how these documents are and why we don't understand them so well sometimes, and that explains many things. Well, we mentioned the timing, it was perfect. And as to the methodology, I want to add something else. It's a document that is long, large. It's a document that is pretty repetitive. It's a document that uh, brings rights that are in the convention, and if we don't pay attention, it might seem the same, but it's the same text. But if you take the word child away and put person, there's not much difference in many paragraphs. So when I say yes, that's necessary, because it's not, if it's not specific for children, if it has no added value, why is it being edited?
I believe that has to do with the methodology and the construction method. And I think that you all need to be made aware these documents need to satisfy many different audiences. all the audiences that were part and that were not part need to be reflected in this document. And this is a very complex work because we have and get a little bit of each one, and that way we have the document. That's really in reality what it is. I believe that in regards to what's essential, the most interesting question for me, or even more complex in regarding to this document, is the idea of the child. That's one of the issues that wasn't solved, and I believe Brazil and Latin America will be able to solve it. But why is this important? If we have clarity of what symbolizes or signifies being a child, which is the one that's the norm being created for, is to have the normative parts. If we have a different idea of what a child is, and that way each norm will generate a lot of contradiction. I believe this is important because in certain occasions where you feel like the exercise of their interpretation of human rights can actually alienate, and I think this is a political risk that can't pass through, because this is a big issue. And as I mentioned, and I will give certain examples, so I'm not just so theoretical, but there are certain issues that are very interesting. The document begins, like many other documents, repeating what are the four principles, which are the essential principles in the convention: the principle of non-discrimination, the right of life and development, and up to now, the rights of the child to be listened to. So these articles from the convention, no one can discuss or contradict that, but believe that this is in Spanish and in English. We have certain variations, and we don't really know why. Because, for example, Article 12 of the rights of the child, and I will read it so that I'm not imprecise. The respect of the opinions of the child. So these opinions, we need to take them in regard to the opinions of the child. So starting what we're seeing here in the document is a dialogue that's not explicit of different perspectives and opinions of what infancy is, where we do have certain normative distinctions, not to mention just the country that's looking for a specific issue in the text, which they will not be able to find. There's good recommendations, but there are issues that I believe the committee should have been more precise and clear, and is not, unfortunately. So there's a theme in terms of categories shown as an annex of terminology, and I believe it would have been great is that the juridical part, or the rights and laws part, would be more precise. But the big issue that I want to refer to here, there's an idea of a child that's not recognized as essential if we use the correct terminology of the Inter-American Court and the theories of Mestre Gaston Galvez. The text has 3 paragraphs in the evolution of children, in understanding that these children are growing, but the weight and the structure are a little bit, they aren't correct, I believe. So I believe there are a few paragraphs that are very problematic here. So let's see. I also would like to explain here that I understand that the normative rights of children in regards to human rights is different from the adults, obviously. The principal rights of the children is the right of protection, because they are vulnerable. In the case of the adults, we have a base of the normative structure where we respect the liberty and autonomy. So it's based on this structure that all the other rights are developed, which is different from the adults. If it was the same, we would have different laws for the children. We were talking about this theme We would talk about how the adults know how to protect themselves from the digital environments. Do you know what I mean? I mean, I have cell phone for only 2 or 3 years, but I have no idea about digital environments. But I think you guys, as professionals and adults, have very clear what protection is regarding to digital environments. And in that way, I'm certain that we all have doubt because it's a great power in terms of technology that is developed in giant leaps. During COVID, AI was in Hollywood movies, and now it's part of our university and schools because we need to reformulate because we don't know what we're doing. In regards to what was mentioned recently, that someone mentioned that I didn't even know that you had a friend named Claudia, and I'm a little bit eccentric, but what I'm trying to say, and I hope you all can understand what I'm saying, it's terrible not only for our children, but just for our adults. We need to translate the rights of children, which are agents with structures, different structures of the adults in that way, respecting their rights, their development, their autonomy, but not to put them in comparison to the adults in the same level. And I will say a little bit as I speak in my own country. I have two things here that I like to highlight. The lack of reference of what's important as a responsibility of the world and of the company on the corporate world is not to be mentioned, but as I repeat myself, in the proportions, I believe we could have put a little bit more effort in identifying the biggest responsibilities. Obviously, in treaties, we know that we have the states, but who are the agents that can actually make these changes true? These agents are the private agents. And I believe that this is not clear enough in the document. The following item, it has to do with families. In truthfulness, what has caught my eye or my attention in this document is that the families are not in the place where the convention actually put them in the Brazilian constitution or Latin America or in the rights globally, in terms that the development of the child in the family obviously is the parents or the guardians, legal guardians. That way they're helping the children to be able to exert their rights in the digital world with no difficulties. I'm not saying that they're not mentioned, and I repeat myself, but the quantity or the times that they are repeated and the importance that is given to school and to these families in this document, I believe, in my opinion, it's very small. It's infamous in regards to what we actually wanted, if we wanted to give a greater impact on the lives of these children with the use of the digital environment. So there are a few paragraphs here. I know I need to start closing up. I know that this is a very analogical conference, as you all can see. So here we have on 16th, the 16th paragraph, we mentioned in regards to the opinions of the children, one of the principles is that children should participate in all aspects of the world with the adults to be able to defend their own rights individually or as a group. Well, we have a lot of these formulations in our documents where the children should be able to participate in the same way that the adults participate as defending their rights. But here we are putting the rights terminologically compared with the adults. But we can see this as a great idea, but this is not what the convention states. And another thing I'd like to point out, and I believe it's imperative to mention in regards to the judicial quality of the text. I shouldn't surprise any of you here, and you can even mention, oh, we all work with the law, but the document has an intention, that this intention as a document and a text could be mentioned in public policies, but also in judicial decisions. And there are a few difficulties, not only to what I've mentioned with terminology, but in this confusion with which is the right or what is guaranteed or what is the rule. So this text, with all these general commentaries here, is not careful in regards to this. And I believe, due to certain issues I mentioned in the beginning, but this makes it difficult. I believe we need to have a moment where we have a great discussion where everyone feels like they're being represented. We actually need to set aside some time to do a few adjustments so that the context isn't contradictory or inconsistent. So we don't have this lack of precision in the norm. And something else I'd like to mention, when I mentioned the idea of the child that's behind the document in terms of human rights of the child, the structure of that is thought of as the rights as acknowledgement of a necessity and not an exercise of will. There are different theories, obviously, but the whole structure of human rights and the rights of the children, that structure needs to recognize the rights as the possibility of acknowledgement, the necessities, and protecting these rights that are mentioned in the treaty. So if we only do rights as an exercise of autonomy of people, this makes no difference in the adult world. And for the moment, this is what we see in the document. And everything that we're seeing here, or what is done after mentioning the four principles, the document mentions all the rights of the convention and cites them in terms of digital environment, with considerations that we are all going to share in general, with the difficulties that I've already mentioned. But there are themes that are very more developed than others. One example here, and it's very important, the issue of privacy. So there are 2 pages, 10 paragraphs or more, about privacy, which is very important. I'm not saying that it's not important, but there isn't enough equivalent paragraphs in regards to the protection of children, in regards to cyber assault, cyber sexual exploitation. So there's an extra protocol and a convention for that. About pornography with children. So we can see the perspectives and we know of the intentions. And I'm sorry, I don't want to delong myself here, but I believe that this interpretation is what definitely need to do, what the committee needs to do, which is what I mentioned. Now we have to be a more normative structure so that the judges and operators don't go crazy thinking, oh, how can I actually solve this? Thinking about the rights of being listened or the rights of the children. So for me, there's nothing new. It's simply if you have this matrix clear and defined and you have a solid base of what is the context of the right, later you can modulate case by case in terms of context. And then later on, that's how the story develops. We have our talks here, our debates, and we have classes of philosophy of the rights. And why do we actually mention these classical authors when we debate this? Because what they used to think 3, 4 centuries ago, the structure is nowadays consolidated, which is what I believe should be in these general norms here. But just to conclude, I just want to read 2 paragraphs that actually worry me. One paragraph regarding to the freedom of speech, paragraph 71 with data, and it's dictated as if children are adults with good intentions. But I believe this is a paragraph that we need to pay more attention because it's formulated in a very confused way. So I'm just going to read 2 and then I'll end. So on the paragraph 16th, we have equality and conditions for adults. So the biggest issue and I'm actually a teacher of penal justice, is that this is very serious, which is paragraph 108, where we have the faculties that the committee predicts in paragraph 20 is not shown here in the document. Or maybe it's in English and it's the same. I don't know what happened here. Sometimes certain things we don't understand, but you all have the phone, and I believe you can actually see this. You can see it on your phone in regards to justice for youth. So children, there is a panel just focusing on this topic, which is a good idea. It's one or two, three paragraphs that talks about how we shouldn't criminalize children due to their conduct. And we are in accord with this. As mentioned before, we worked many years with this, some of the people here. But the way that paragraph 108 is formulated, the sexual content that's generated by children that share with consent, and here we already get here in the category of children, which is very difficult, like consent. So it's exclusively, sorry, I'm talking about sexual content. So it's a private use exclusively, should not be penalized. But for private use that they share, so basically what this paragraph says, to depenalize conducts in regards to the protocol that should be considered as penalties. I know some of you are a little bit lost. I know this is very technical jargon, but I think this summarizes everything that I wanted to say today. I'm almost done. And this is a recommendation so we can depenalize, so that we shouldn't criminalize children. In that way, not affirming that their conduct is not illicit, because I know maybe adults could be part of this, but not in a way in terms of these categories that are very troublesome. Children can consent in free option with sexual activities. So this is a very complex issue. If we're going to talk about this, we should have been very careful with a paragraph that was written this way. And I repeat myself again, where we should have had an opening here for the people that actually wrote this document were aware or wanted exactly this. So the time defines infancy. We saw this with juvenile issues. Time is something that connects with technology. And why do I say that? It's due to this aspect of how quick technology changes. So rights always arrive late. When we actually be able to regulate something, and we used to mention that 30 years ago, so can you imagine now with digital technology today? So I ask myself, do we really need, or does the committee really need to have an observation to talk about reach and context? I know the committee did what they could, but there's a whole debate of is this useful or not? If the matrix is consistent, if the interpretation is systematic, and if countries like Brazil that are the leadership in this process could use this, so we don't really need a general commentary in regards to other issues.
But it seems to me the ability of performance of this general comment is more symbolic, or is more of an impact of regarding its content itself. If we could see to the content, we could have difficulties. So talking about technology, we should just remember the general picture and recover the interpretative exercise countries do when they internalize the international law, especially from the Inter-American Court of Law. So the work the Inter-American Court of Law does to translate and apply international law from the idea of the broad comprehension of the rights of children and teenagers is known throughout the world. So I think there is the in the interpretative ability of the jurisdictional bodies is the translation of uh, the legal documents the countries do, and in our countries is where we can find the best interpretation of the rights of children in the context of Latin America. We are in a we have very specific times, but the challenge of international law says states must treat children as children, still in the digital, especially in the digital surroundings. So if we don't lose sight of this, and if we don't know how to do this, well, the risk is to get confused and put children in the same level as adults. So we have to be careful so children, if we are careful with children exercising their rights, we'll have a promising future. Thank you very much. Thank you very much, Professor Mari. I think the contribution of Professor Mari was very valuable, especially by leaving it clear for us that there's a difference between the grounds of human rights in general, for people in general, adults, I mean, that talk about freedom as a fundamental right. And in the case of children and teenagers, we're talking about protection as a fundamental right. Our major challenge seems to me was pretty clear, was to evoke effectively the principle of progressive autonomy and contextualize it within our own reality, especially the Latin American reality. So very valuable contribution. It seems that windows are open for us to think in this conference on that perspective. The major challenge is to do what's up to us as adults, which is the full protection, the observance of the rights, the progressive autonomy of children and teenagers in our own regional progression. Anyhow, that's our present task. Thank you very much, Professor Mari. Thank you very much. We ask you now to take an official picture for the record. All right. We will carry on with our activities now.
Dando seguimento.
Carrying on with our activities, ladies and gentlemen, for the presentation of the report implementation of General Comment 25 of the Committee of Children about the rights of children with regards to digital environments. The panel will be integrated as moderator, the Dr. Sofia Cobo. As panelists, I invite the researcher of the Ibero-American Center for the Rights of Children, Dr. Diego Cordoba. I invite also Dr. by the Federal University of the State of Rio Grande do Sul, Professor Emily Laís de Oliveira Matos. I invite Mr. Co-Director of Data Privacy Brazil, Dr. Rafael Vananta, and I invite the editorial manager for Latin American History Foundation, Dr. Maria Candela Zunino. I now give the floor and the moderation to the moderator, wishing you all great work. Good morning. While I had the pleasure of greeting you already, and it's once again a pleasure to be here with all of you. We are about to begin the first panel of the presentation of the report drafted by Sideni, implementation of observation number 20, general comment 25 of the rights of children in digital environments. I will introduce two researchers that are part of this panel that also participated in drafting the report. First, Diego Cordoba, that was also the coordinator of the report. Diego is a lawyer, graduated by the University Portales of Chile, in specialist in rights of communications, protection of audiovisual rights, training in patrimonial civil law by the University of Portales. He has over 10 years of experience in technological regulation, has worked in legal advisory about protection of personal data, electronic trade, brands registry, and legal analysis and legal rights of children in digital environments, AI, neuro rights, and cybersecurity. He also has developed activities in teaching in the University Diego Portales in Central City, and also in the School of Economics and Businesses in the University of Chile. Welcome, Diego. And Emily Laís de Oliveira Matos. Emily is a professor at the university, taking a doctorate in law by the Federal University of Rio Grande do Sul. A scholar at the Federal University of Sergipe and graduated by the University of Tiradentes. Welcome, Emily. And also, we have here to comment on the report, Rafael Zanata, co-director of Data Privacy Brazil. He's a postdoctorate researcher of the School of Law of the University of São Paulo. He's a doctor by the Institute of Energy and Environment of USP, with training by the Institute of Law at the University of Amsterdam. Has a master's in law and economics by the University of Turin. Also a master's in philosophy and general theory of law by the School of Law of the USP University. He's graduated by the University of Maringá, was a member of the Vulnera Group, the University of Brussels, and was a visiting researcher on platforms and digital economy at the New School. He edited the books Collaborative Economies and Rights and Law, Digital Data and Competence. He is author of Data Production in Brazil, Vectors of Interpretation. Welcome, Rafael. I don't know if we'll have Maria Candela Zunino online. I'm here. Can you listen? Yes, we can hear you. We hope to be able to see you. We can't see you yet, Candela. It's a pleasure to hear you and have you with us. Candela is a senior manager for legal programs for Latin America from Thompson Foundation, with over 10 years of experience in legal environment specialist We can see you perfectly now, Candela. A specialist pro bono coordinated the pro bono practice in Praga and was a legal advisor of government of the city of Buenos Aires. She's a master in public administration by University of San Agré and a lawyer with an honor diploma by UMA. As part of Pro Uno University in Argentina and as part of the directing council of CESNIC, an NGO dedicated to research, education, capacity building, and advisory in food and child nutrition in Argentina. Welcome, Candela. It's a pleasure to see you. Thank you, everyone, ladies and gentlemen, all participants of this panel. I'm very happy to be able to share this panel with you today. Let's begin with the presentation from the report by the coordinator himself, who is from Cordoba. Thank you, Diego. Thank you very much, Sophia. The clicker for the presentation. Okay, perfect. Good morning. I don't speak Portuguese, sorry. I'll carry on in Spanish. I am Diego Cordoba Yukit. I am 35 years of age. I am from Blanco. I'm white, brown hair, around 1 meter 80, brown eyes. Have a dark gray suit, white shirt, and a pink tie with red details or dark pink details. Thank you for the invitation, especially to the organizers, Sophia, who follows me, and Paula, the translators. I hope I don't make your lives complicated. Having said that, I will present the report I have the honor of coordinating and directing. First of all, as mentioned, Sophia, it's a compared study of the implementation of General Observation 25 in different jurisdictions of reference. And what I would try, we seeked as a general goal is to recognize, like the general observation, the digital space as a central, a core environment for children and teenagers. And over 90% of teenagers over 13 use internet daily, with 46% almost permanently in that environment. And that brings opportunities, but also challenges. And within these challenges, exposure to harmful knowledges, uh, digital surveillance, protection of personal data, problems of misinformation, sexual exploitation, etc. The goal of this study, of this assessment, the survey, as I mentioned, is to describe and compare like a picture of how the state of the situation regarding the implementation of this general observation in 9 countries of reference that are Argentina, Germany, Brazil, Chile, Spain, Florida, US, Italy, and the European Union. And now I take the opportunity to extend my thanks. This work was done jointly between Sideni, Thomson Reuters, and thank you, Roslo Foundation, with the support of the German Foundation Exica in Argentina, the Federal University of Rio Grande do Sul for Brazil, Cariola Diaz Perez Cotapos from Chile, Latham Watkins Perez, that was in charge of developing Spain and Mexico. On the US, specifically Florida, we have Hogan and Lovers, and then Latham and Watkins from Italy, and Latham and Watkins Brussels that developed the chapter of the European Union. And here comes, I'd like to comment in the other tab, the risks and challenges. So that also brings opportunities. These opportunities is the launch of rights and freedoms like have the real world, we have the digital world, and we say is identified by children themselves, consulted by for the development of this general observation. So observe that access to information, freedom of expression, awareness, freedom, association, and the launch of your own personality. The fanatics gather around the Harry Potter community. They are gamers. They football players of Madrid community versus Barcelona, I imagine here you have communities from different football teams, etc., and at the same time, challenges of rights to privacy and identity and protection of identity. And how do we bring this report? And I want to invite you to read it also. We also developed 4 axes. So first, what we called legal frameworks and fundamental definitions. First of all, we'd like to, I'm sorry, I come back. Methodology we implemented, we sent you a series of questions to all the participants, all these participants that helped us. So they told us how it is, or if at all, the implementation of the general observation in their countries. And having said that, the questions were on these axes. First, legal frameworks and fundamental definitions. We'd like to know if you had the definitions of rights of children and teenagers in digital surroundings, if that was included in any law, and if it wasn't defined at the legal level, see if by chance at the level of any authority, any ministry, at the governmental level, there was any document that defined also the digital rights for children and teenagers. Second, regarding policies and public actions, we'd like to know the authorities of each country analyze that care for rights of children and teenagers, especially in digital surroundings, and at the same time also to know the realities or the concerns of each country and what bills of law are under approval, and we see different topics like grooming, share, harassment, there cyber ludopathy, and others that not so much the concern of harmful content, but also following that, and many public policies around training and define very well proper label for given contexts and etc. On the other hand, also as mentioned previously, technology advances very much faster than the law. So there is a part that was important, and that was knowing how these matters were regulated from the self-regulation point of view, how technology companies have developed the level of good practices, the development of the rights of children and teenagers in the digital environment. And there we saw many experiences in Spain, the regulation of influencers, in Chile, a special norm regarding publicity online, and also electronic trade, etc. And lastly, we were interested in knowing the sanctions regime, and we could have 3 administrative logics through fines, civil logics through indemnizations for damage, and also compensation for damage, and also penal consequences. And lastly, we tried to find out how these courts were working, and we found enough volume to approach the jurisprudence of children's and teenagers law. So regarding the report, we have more specific points for each country. And because of time, I will jump over this part, and the presentation will be available with the main findings of each country. So not to take too long, I'll move on to the common points. Well, there's a convergency, and I believe driven by the European regulation for data protection, in Brazil by the personal data protection law, and then Chile also in that trend of raising the standard in the personal data protection with a special bill that is ready and comes into effect in December. So under that logic, we recognize personal data of children and teenagers as a special category that comes expressly mentioned. Another relevant point is to follow not only the forbiddance or limit access, but also to educate. And all these children and teenagers will be adults, as mentioned previously, that will go into digital life and must have good tools to navigate in this environment. And then very varied in the jurisdiction, focusing on digital violence risks regarding grooming and penal types that develop in digital environment, harassment, exploitation, deep fake. These are major challenges regarding AI and other kinds of emerging damages.
We also see that with the advancements of the regulatory regards in Europe, they have a culture of protection of data that's more advanced, more specifically because they have EI regulamentaries. So what we also see at the same time is that there's not a lot of specialized institutions in this topic. So it's important to recognize this digital ECA. And I'd like to say congratulations to our host because these are norms that are constructed with the rights of the children and automatized by the protection data with EI to be able to make the progression of the rights of the children and teens. And I'd also like to mention that we do have challenges and opportunities to close the gaps or to help make them balance in terms of use and effective rights. And that way, holding hands to be able to promote the rights of children and teens with digital ECA. So I think it's very important to deal with the norms and be able to develop a digital rights that build not only with a basis of norm, but with logic of integrated advance and always hand in hand with the children, which are the future, the new future of adults that will be navigating in the internet. So we need to address this in the progressive years and put these practices, compared practices, and protections based in general data, not only in Latin America, but North America and Europe, and think of better practices to be able to advance and understand the well being of the children and teens. And I'd like to conclude with a reflection and an invitation. So, this is a movie that is on Netflix. I don't know if you've seen it. It's called The Very Eccentric Life of Ibling. So this is Norwegian youth, and I think this is a good news that I'm going to bring because this is a Norwegian youth that would play 12 or plus hours connected to the internet. And we know that these gamings online that he spent more than 12 hours playing, and it's not necessarily a good news, but in regards to this teenager in particular, he was very sick. And throughout the years, he became even sicker, and his parents gave him the liberty to navigate the internet in the best way that he thought. So I'm going to give you a spoiler of how the movie actually begins. So the movie actually begins with the death of this child, the death of Ebling, which was this alter ego of the child, not necessarily the child. And then later on, the children start receiving letters and messages of a lot of affection. So, what happened? This Norwegian boy that was condemned to live his life in circles inside of this digital game, he decided to bring his personality on the real world and actually interact with people from other countries. So now he has a girlfriend, he's seen the world. So, what am I trying to say? It's important for us to have norms for gaming online. But, and I also invite you to please see the movie because it's very interesting. And it's very important for us to be able to balance this in a very helpful and positive way because technology gives us ways of seeing a child that's apparently condemned of living in circles, but also invited to see the world firsthand. So thank you very much. Thank you so much, Diego. This report basically shows us that the implementation of number 25 of the jurisdictions that we analyzed are things that still present a lot of challenges for us, as you mentioned before, with this report, with this normative focus and legal fragmentation and fragilities that we still with, and even the lack of structures that are more specialized that could limit a lot of things, but the capacity of the states to safeguard the rights of children and teens. So thank you so much, Diego. We're going to go to Emily Oliveira, who is going to show us the report Brazilian report. In regards to this document, thank you, Emily. Good morning, everyone. I'm very happy to be here today. First of all, I'd like to describe myself. I'm a woman of 34 years of age. I'm parda. I'm brown. I'm wearing a black suit with black pants. I have long black hair and I wear glasses. I'd like to greet the table, more specifically, Doutora Sofia Cobo, but also Diego and Rafael Zanata. So I'm very happy to be sharing the table, the round table with you today. I'd also like to thank Sudani for the invitation. And beyond that, I represent the University, Federal University of Rio Grande do Sul. So I'd like to thank the university and the postgraduate degree of the state, and also our research group, Reserva Juve, because the report that we're going to showcase here today is aligned with the debates that we actually have in our research group. So this report that we bring here today and present to you all, it was elaborated by myself with my advisory, Dr. Ana Paula Mota Costa. And this report is actually part of this comparative study of how the countries that are part of this Ibero-American context were put together the comments number 25 of the UN. So we here showcase how Brazil hosts this directory and in what way it was able to do this alignment, not only to the normative aspect, but also with in regards to legislation and jurisprudence, but also with institutions and public policies that Brazil was able to put together to follow up with the UN commentary. I think we all know that all of us that study infancy and children in Brazil, we know that for decades, Brazil has a lot of compromise with adolescents and children. And we already have a very important legislation. And it's important for us to be here today to debate the implementation of the digital ECA with this context that we are all inserted, which is the digital environment, where this area of information, where we are all technological beings. So we need to actually debate about children and teens in Ibero-Americano and Latin perspective is inserted in this universe. So we need to actually think of ways to protect these children due to these challenges. But the main objective here today is that we can have the presentation of the report. So the first thing I'd like to highlight here in that we mentioned in the text is the UN General Comment of the UN and the resolution of the CONANDA of 2024 that helped us discuss the text of Digital ECA last year. So the main objective to begin with of this report was to highlight the Digital ECA as this new legal framework so we can think about implementation. So when we're talking about comprehensive protection based on the best interests of the child, aiming to ensure privacy, safety, mental health of these children and teens, and access to information. So there is a character of anti-discriminative character to that all children and teens to be able to access this in a safe way. The main point here is to think of the legislation where it brings where we need to think about infancy and teens as ultra vulnerable and think about progressive autonomy of these children and teens so we can think of ways to make sure players are responsible, be it companies or the states or families, in regards to protecting these children and teens in the digital environment. So last week, I think we're aware that digital ECA started and was put into place. On the 18th, we had the beginning of the decree that actually is part of the regulation. So a point of connection between this new law is the dialogue with other laws. So the ECA by itself, G of 190, the Consumer and Protection Code, the Civil Rights of Framework for the Internet, the General Data Protection Law, all these instruments are aligned with the context of the digital ECA and strengthen the protagonism of this legislation. So the main axis of protection would be this one of prevent and mitigate risks of exposure to content such as sexual exploitation or manipulation, predatory advertising, and pornographic content of this child and teenager. So the main objective would be this protection of an integral way. So part of this report, and Diego mentioned that we do deal with a lot of questions, and it was structured in regards to this with questions and responses of how Brazil positioned himself in legislation aspects and public policies of protection. So we talked about the duties and obligations that the platforms have starting now in regards to the protection of children and teens. So these obligations are aligned with the UN General Commentary and with CONANDA. So we have the regards of design and privacy and the prohibited practices. We had reward boxes that we know that now will not be able to put into place, and the withdrawal of content that actually is bad for the rights of the child and the teens if this actually happens or violates any of this. Another important part of the text is parental advisory. And we even brought here some public policies. Obviously, we had other public policies that weren't be able to put into this presentation, but these are policies that our own country helped fulfill, where we had national policy of the prevention and combat of sexual abuse and exploitation. We had a law that prohibited the use of cell phones in schools last year, that started in effect last year. And also Brazil still edited some national strategies to even be able to reach civil society and understand certain concepts. So we had the strategy of mediatic education and connected schools in 2024, and the national policy in the digital environment that was created by the in regards to Conan. Brazil was also focused in creating guidelines that are now being publicized so that everyone can have access to the information in regards to this digital context. So we have the booklet of the protection of safety in regards to schools of 2023. We also had the guidelines of kids and teens in regard to screens of 2024. And we also had a glossary of the protection of children and teens in digital environment. From the viewpoint of oversight and accountability, this advancement of Brazil in this debate brought a very crucial point for our own national agency of data protection as oversight and accountability of companies, where we can audit algorithms and even penalize if needed. And also in terms of responsibility, Brazil, we have a three parts responsibility, where we have responsibility for administrative, but also penal and civil areas. And we also have jurisprudence of the Supreme Courts that are going to gain more importance while we're debating this implementation and the actual implementation of digital ECA. Also on the 18th, we had one of the decrees that our government brought to the table, which is the most important one of them that I highlighted here, which is the 12,880 of 2026. That is a regulation of the rights and protection of adolescents and children. In that way, helping to regulate digital ECA, and we bring the prevention of the rights of children and the prevention of excessive use and manipulative practices. And there's a lot of items here to highlight, but also the creation of Triage National Notification Screening Center by our federal police, so we can actually receive any information regarding that. My time is almost done, but I'd like us to really understand the main point here is that we are at a starting point, because from now on, our job is just beginning. Our work is just beginning, and we are very happy to be here today with you all. We're just a week regarding today where ECA Digital started being implemented. So I believe as our right, as a defender of the rights of children and teens, our work is just beginning. The challenges are many, and we need to unite forces so we can have a whole ecosystem for the protection of these children and teens in the digital environment. So please, let's unite forces with the families, with the state, with the judicial system, with us, our own researchers of the rights of the children's and teens, so that we can actually follow up with implementation and the transformation of the law, and also the regulation of the use of the internet by children and teens. I'd like to thank once again the opportunity to be here today. For the ones that are following us at home online, I extend my thank you and thank you. Thank you so much, Emily. It was a pleasure to be able to read this report from Brazil. It's very enriching, and it highlights with the publication of the digital ECA, not only we created a normative instrument, but beyond that, with the implementation of last week, we created what we named here today the ecosystem of protection of children and teens inside digital environments. I'd like to highlight that for me, it's very important the national policy of digital education and the creation of these institutions of be able to regulate all of these. So thank you so much. Thank you so much. Just to continue what we've been saying, thank you for the interventions. Rafael, Zenata, thank you so much for the opportunity to be here today. And well, uh, I'm a white male, black hair, and I have a beard, but today I am just with my mustache for this presentation. I'm wearing a suit and a burgundy tie. I'd like to begin thanking and giving my thanks to Ana Paula and Sophia and Diego. Emily, thank you so much for this event. I think it's very important. It's the first official event of the Supreme Court of Justice in regards to this theme, and I'm very happy that we had the following day an event which is very important with the materialization in this judicial world of the rights. And also I'd like to say my congratulations for all here. And I'd like to begin my speech with what is already inserted in our law to say that the digital ECA is part of recommendations that is part of the general comment of number 25, but more of a transformation of soft law and hard law. And I'd like to highlight why there are connections between those two. I am the director of Data Privacy Brazil. Just to give you a disclosure, we are Institute of Technology and of Education. We've been working with information for a lot of public agents with part of NPD.
And with the support of Alana, we'll do a digital literacy course. So thank you for the leadership of Alana in building this agenda. And we work upon this topic for a long time. I see Julia Mendonça, researcher at Data 6 years ago in this personal data and childhood project. And we work constantly the development of an agenda that gathers digital right and protection of uh, personal rights with the ethics and the grammar of the rights of children's rights in Brazil. Last year, we organized the fourth edition of the International Conference, Data Privacy Global Conference, with the digital ECA as a core topic with active presence of the Ministry of Justice, ANPD. And it's very important to observe how much ANPD is transforming itself because of digital ECA. This is one of the core points of the report that is worth to think of because of the materialization of the application that will happen over the next few years in Brazil with ANPD acting with its legal competence for implementation of digital ECA. Here are many of our projects. I leave the reference to, so if you can access, presentation will be also available. I want to contextualize digital ECA in a larger context. Emily mentioned of policies of children protection. Digital ACTA is not a FELCA law. It didn't come as a meteor and fell after Felca was in a Roda Viva TV show, and he says he's not responsible for Felca law. He says he doesn't know the legislation very well. He's finding out now, and there's a debate that is very influenced by the general comment of the UN. Alessandra Vieira's production since the beginning talks to the General Comment 25 and tries to change the rules of the game, talking to experiences of the United Nations, United Kingdom, but bringing shared responsibility. And the focus of digital ECA is in the companies, is in the creation of a culture that is preventive and mandatory conduct and a strong sense for big techs and the technology companies. And that fits evidently as very well mentioned by Emily, in the materialization of the set of public policies that is connected with the national first childhood law, general data protection law that has special chapter for children and teenagers, uh, countering malpractices. There's a whole framework of public policies and drives digital ECA. I believe that effectively it's notable because it approaches new kinds of damage. I think that's important. That has been said in many public speeches. We must be careful with a discussion that is centered only in risks, because risk is a virtual event that is hypothetical. And here we're talking about damage, concrete damage, existing damage. Digital ECA is not interested only in risks. It approaches already mapped damage. These damages are well documented. Last year's research and TV and media in general showed that among 4,000 youngsters interviewed, a large percentage say they are addicted, and video pornography is related to influence from influencers like Andrew Tate and other misogynist uh, influencers that must be countered in digital environment, and also the cultural uh, digital culture and many horrors we've seen in Brazil and throughout the world. In the United Kingdom, this has become a major problem. We have many we have risk management regarding this material that is easily transmitted to children, pedophiles that use deep fake to produce these images, and also the issue Daniel Beck mentioned on the TV show yesterday is the issue of the induction to the addiction and behaviors that are harmful for children and teenagers. That's also the focus of digital ECA, and it brings this clear focus. So I think digital ECA brings like there are many novelties and definitions. What is profiling, driving, parental exclusion, and also big techs. that is connected to the change of mentality in law. We're not interested in having damage compensated. We are interested in taking on the responsibility because the possibility of producing damage should be avoided. That's totally aligned with the General Comment 25, paragraph 69, that brings the obligation of child's best interest in technologies designs. That's an important point for digital ECA. Also, digital ECA defines a clear content forbidden. So that's what will be inspected with the report mechanisms in the legislation. Dissemination mechanisms promoting bets, porn culture. Many youngsters are having accounts in OnlyFans, and they're being groomed in platform contacts and Instagram. So this is illegal. It can't happen. Companies have the obligation of removing that, and community will be called upon in this joint inspection with the federal police, ANPD, the screening mechanisms. And as I mentioned, I think an important point related to General Comment 25 with paragraph 109 and 72, talking about the parent supervision or design must be made easier to make parents' action easier. That will bring to within digital ECA an idea of privacy and security by design. And we will observe over the next few months, be by Reddit, Roblox, or many platforms, many meaningful changes in the design. That's not because they're good, not because they are want to do the right thing. It's because they're sanction and inspection mechanisms. They will be inspected and sanctioned. It took a long time for companies to have good faith and do it, and they didn't. So YouTube case was only created after $1 million sanction imposed to them. So they want to look for the most profit, and they're facing international debate about the spies for the children's best interest. And in digital ECA, they are placed into rails, so to say. They have to do it. If not, they'll be sanctioned. So I think the issue of age checking, I want to mention that point, and the reinforcement provided in Decree 2680 that Secretary Victor mentioned. It's important because effectively there are a series of open points in digital ECA. The chapter of age checking is still a little vague. Yesterday in the TV show, it was said that that's not very clear, but the decree is very advanced. If you can read Decree 12,680, please read it. It's a decree that brings a whole concept development of how ANPB will understand age checking and will privilege mechanisms that are more protective to children's privacies itself. There's a lot of misinformation saying they will demand for face recognition. That's not true. The agency is working upon that and saying that age checking can be done by many techniques, and the decree points a way for this age checking to happen. So this parent supervision gain will make more sense over the next few months for parents. It's a concern of many ideological spectrums. If what's the repercussion for the family, so they can have this dialogue with children and teenagers, can have straightforward talks about how this is used, and have this parent-child digital ECA drives this, because it brings a set of obligations. So this parental supervision is guided. So we run the risk of having these parent supervision made difficult. And parents may say, this is too much work. I won't do that. They just let it go. But it has to be clear and has to be easy, and has to make parent supervision easier. Last comment I think I want to do is that I considered myself as a data protection academic. Paragraph 42 of General Comment 25, the authorization of profiling and use of individual and collective data that can't be used for trade purposes. And that's one of the major contributions of Digital ECA in Articles 22 and 26. That's very important because no kind of group data of children can be used for commercial trade, if not for a specific use of that app. So we can't have an app that monitors data of hundreds of children and profile in commercial interests of children. Even if it's not a personal thing for each child, you can't analyze the data in batches. It's a very rigorous conduct providence with general comment, aligned to general comment 25. And the role of the agency is important in the implementation of that arrangement, that due process of law in digital ECA that constitutes a micro legal framework. In 82, legal framework was created, and Digital ECA also creates a digital framework, legal framework, and the agency ANPD has clearly worked in the sense that it'll have a role of instruction, of training of the community for these points. And for the ones who are curious in understanding what unfoldings of digital ECA, we have followed the guidance from ANPD. ANPD published this week a guide for age checking, published its schedule of how it will instrumentalize this enforcement throughout the year. And ANPD will be effectively the guiding light for the technical side of digital ECA, jointly with CONANDA, MDH, all the system, but from the more technical standing point, the interpretation of the application of digital ECA, we have to look towards ANPD, and that for us who are activists in digital environment is excellently used. Thank you very much. Thank you very much, Rafael. You conclude that digital ECA situates Brazil among the regulatory frameworks that are more advanced for the protection of children and teenagers in digital environment, according exactly Decree 12-880 from 2026, the concrete action of the National Agency for Data Protection must be guided by a focus based on risk and regulation. You also highlight important challenges that are on the table, which is to consolidate the screening centers, improve articulation with the federal police, coordinate ourselves with other institutions for online data protection, highlighting the priority of this initial implementation phase to ensure digital legal legitimacy. So it was a pleasure to have you here digitally. You're our first virtual participant. Thank you for being here with us. You have 12 minutes. Thank you, Sophia. Thank you to the panel. I thank the conference and Sidney for inviting me. I will begin with the self-description. I'm a white Latin American. I have brown hair. I use glasses, and today I have a blue shirt, and I am 37 years old. I'd like to tell you, and it was interesting to listen to the research you did and the opportunities for improvement and where you have the advancements and practices in the different countries and the regulatory frameworks that were being analyzed. I'd like to tell you how uh, the Trastienda was. I'm part of Thomson Reuters Foundation. From Thomson Reuters is the service company, and what we do in the foundation is we potentialize the experience we have in means of communication in legal data topics to facilitate access to rights and promote accountability. So I'm part of a program which is the Foundations program, and that facilitates, support, connects nonprofit organizations. We have legal advisors from the whole world, companies that advise pro bono in a pro bono manner. And a way of doing that is through legal research projects. We also facilitate the pro bono work for more operational or transactional issues in the organizations. One of our pillars is to offer research, legal research. So in June 2024, CNA connects with Trustro, and we bring this interest for analyzing how this is being applied in different countries throughout the world. This general observation number 251, and we could contact Sideni through 4 offices, as mentioned by Diego at the beginning, which did the analysis in different countries. And as a result of this, we had the report we were discussing in this panel, and then we add the research done by Brazil, which is very valuable when doing that evaluation. So I we've mentioned, but I thank once again this company who did follow up on public research in a pro bono on a free way, free of cost. So Wenkes did the analysis of different jurisdictions, different offices, as mentioned by Diego at the beginning, but they approached all the analysis of the European Union, Germany, Italy, and Mexico, and Argentina, and Cayo Diaz in Chile, and lastly, they did the Florida analysis in the United States. The report is available for you to read and analyze. I invite you to do so. Very valuable information is there. And I also understand Sideni has the Brazilian one. After all that, follow up. Thank you for the invitation once again, and it was a pleasure being with you. Oh, how nice. Yes, thank you, Candela. So for us, as Sideni, it was a pleasure to collaborate with the foundation. Thank you very much for your drive and for broadcasting that report. And well, finally, before we close the panel, I want to thank each and every one of the participants of this panel for their participation. Thank you very much for sharing your knowledge. Thank you all for sharing your knowledge. And according to the content of the agenda, we will begin a dialogue with children from the region according to the participation rights, right to be heard. Most of them are now in school, so we had to ask permission to the schools so these children could be with us. And so let's begin in a few minutes the panel called The Voice of Children and Teenagers. Thank you very much, everyone. We thank the speakers for their uh, speeches, and now we will undo the panel to carry on with the event.
Senhoras e senhores, compõem o painel A Voz das
Ladies and gentlemen, we have the panel of the voice of girls, boys, and adolescents. As the moderator, we have subdirector of strategy and researcher of digital with the rights of infancy, Doutora Paula Vogel. And we have the senior researcher of the Ibero-American Institute for the Rights of Children and Infancy, Dr. Juan Medding. We have online representative of Brazil, Tomás Mario Macio, as representative of Chile, and José Ziampielli as representative of Spain. I pass the word to our moderator and wish you all a great work. Thank you so much. Good morning. Good afternoon, almost. So first place, I'd like to thank the hosts for allowing us to have this international meeting. For us as a team, it was important to think of how we could integrate in this room the voice of the children, boys and girls, obviously, that don't represent the region, but we thought it would be important to hear from them, ask them. And for that, I have by my side Juan. And with Juan, we thought that children know more about digital environments and are more specialists in those areas than us. So what we did was we extended an invitation where we have boys and girls of Brazil, of Chile, and Spain. They were asked, obviously, to not be at school today and authorization of their families, and they are going to start following us. We have Maria Ignacia here. I think she's on the phone. Maria Ignacia is from Chile. And for everyone that's here following us, we're going to have a dialogue about three issues: advantages, risks, and a final commentary. So I'd like to present the children that are here today. We have João Vitor. João Vitor from Brazil. He's 16. He is right now in school, high school, and he is in Belém do Pará. We also have Sara Julia. Sara is 17. She's in school as well, and she's in Porto Alegre. So the magic of the internet, have in Spain, João Pierre, who was actually starting from Ecuador. He was born in Ecuador, and he's from the first year of high school, and he loves to draw. Jose was actually born in Colombia. He's 12. He's on the 6th year of high school, and he really enjoys soccer. And from Chile, we have Tomás. Tomás is on the 4th year of high school, and he lives in Los Angeles, in Concepcion. And Tomás, or Tommy, who is here, he's part of the Consultant Council of Children and Teens of the Institution of Chile, gave them permission to give a little bit of help to public policies, but also have Maria Ignacia. She's in the south of, she's in the central part of Chile in Valparaíso. And she's also part of the Consultative Council of Children and Teens. I pass the floor to Juan. Bom dia, eu sou Juan, eu sou homem, I have white skin, I am 170, 172, I have green eyes, white hair, and sometimes I have a beard, sometimes I don't have a beard. Right now, I'm wearing a white shirt with green details, and I'd also extend my thanks to be part of this meeting and to everyone that's here today to give me the opportunity to share this space with you all, and also with children, boys and girls. So I'd like to start asking them, but actually telling them that this conversation is not that we're going to ask them questions and they're going to answer us. Here we have a two-way conversation. There's no wrong or bad answers. You can share your experiences with the use of the internet, with the devices, and etc. So the first question, so we can begin this conversation and we can actually follow in this direction or in another, I'd like to ask what are the advantages that you have in regards to the use of the internet from your phones and platforms at home, at school? What are the opportunities and the advantages that you think these devices collaborate for the daily life? Would you like to begin, Domi? Tommy, would you like to begin? Hello, yes, I can begin. So I'd like to say good afternoon. It's 2:15 now, Chile, in the afternoon. So to answer your question in regard to digital networks and the internet, for me, generally, it's very good. I learned a lot and it allowed me to connect with great digital experiences, video games, classes, conferences like this one. So I believe it's a space that's very good for the development of the daily life, but also of knowledge. So these are spaces where we have recreation activities, where we have knowledge. Obviously, there are distractions, but in generally, these are spaces in my environment that we use as a benefit for knowledge. And as an example, here in Chile, we had recently the law 2021 that limits the use of cell phones in schools and institutions. So that puts in place a way of to regulate the use of these devices so that they're not misused, but better for the education. What I saw personally is not that it's bad, but it's a change in regards to artificial intelligence, where it's more common to see children with phones. So we need to be part of this daily work because this is a new reality. So we should take advantage of it. Thank you. Anyone else would like to speak in their perspective in regards to this issue? Good afternoon. Can you hear me? So in regards to this topic, I'd like to bring my own perspective and opinion is that social media and technology, we were already born into this technology generation where we have more contact with technology than our parents, let's say. And obviously there are benefits. I use a lot of my social media because I want to in the future work with art, music, theater, and inside social media, we have a lot of ways to showcase ourselves, to showcase our talents, our abilities, to be part and have access to good opportunities, not to mention the contact we have with other people. Sometimes I have a cousin or a brother that lives abroad, and that social media brings us back together. We have a contact with our family members and friends. And here in Brazil, we have this law now of not to be able to have cell phones inside schools during classes and during our breaks. And most of my friends are not enjoying this. They don't think this is a good thing. But I personally think that as technology has their benefits, they have their downsides, which is the use in excess or the addiction. And I saw this new law as an opportunity for us to go back and develop our creativity, our sense of criticism, because sometimes we're so caught up on technology and what other things that we end up not developing or having as much creativity as we had before. The use of the technologies to use things regarding school, like writing and essays. And sometimes we get so caught up in that we don't develop our own abilities. So I believe that yes, technology have a lot of benefits, but we need to continue to care and be aware so that these excess is not prejudicial to our daily lives. Thank you so much. We're talking about the opportunity and the advantages in regards to the opportunities that the internet has in our lives. So would any would like to talk a little bit more about this theme? It would be perfect. Well, I could well, for me, it's great to talk about my family that's in Colombia and my friends that are close to me. Thank you so much. May I speak? So I believe that the internet can help us denounce many cases that are happening. For example, climate change. I'm part of the island of Caratate in the Amazon in Pará. I'm right now actually in the state of Piauí, more specifically in Teresina, which is the capital of the state. I'm part of the Forum of Development of the First Infancy and talking about the first steps of the child in the world and what actually affects this child. And as a young activist, I use social media to denounce some of climate crimes from my town, from my country, and even globally. A lot of my activism and my work uses technology. So I think being of this and working with the internet is getting a local issue and bringing it to a global viewpoint to show of what's happening in the Amazon, in the outskirts, can also be seen for the people that can actually make decisions. And we need to understand that this excess of exposition in the internet, more specifically for the children that are activists, do have its bad sides. We have obviously the divulgation and criticism and threats. We also need to have a follow up with a responsible person because it's the first moments of the child and the teen that's being exposed. So, any word, any threat is going to affect this child or teen who doesn't have an adult that's there mediating it. So, thank you. Thank you so much. Would anyone like to share their opinion or experience of the advantages that they see on the internet? If not, we can go to their second theme or topic. We'd like to know what you're thinking. But our second topic has to do with the threats and the risks that you all see or know or aware of friends that happen to them in digital spaces, or any threat or violence or risk. So whoever wants to begin talking, feel free. I'd like to begin, por favor. So the first thing, regards to abuse and cyberbullying, not only myself, but many people that I know, we've already had to deal with this. And it starts with small things, like with an offensive commentary on a video or a photo, or a message that's offensive. Small things that begin between teens and more uh, risk, where we had men that actually were part of our social media, which happens more with girls, but it also happens with the boys, where men that come with bad intentions that have access to our social media and do a lot of abusive comments and threats. I saw a lot of girls and teens that had to deal with they thought they're dealing with scams. They thought they were talking with friends, like a new friends in the Instagram, and then they actually see that the person that's behind that female facade is usually a man with bad intentions that's going to start to force the girl to do to send photos, videos to satisfy their own wills or desires. So this is something that's been happening for a while, but we're just now talking about this, about cyberbullying and the abuse of social media. And it's very important for us to adopt measures to take care of this, to regulate this. As I mentioned before, we were born in this technological generation. We have a lot of access. We have access to a lot of things that we shouldn't have access to. We have children who have social media accounts and have access to Instagram, TikTok, Facebook. And these social media are mined or filled with people that have bad intentions. So it's very important, it's imperative that we have a higher regulation for higher protection. There are many cases that are not denounced or reported, and it's a lot of data that we don't have of abuse and cyberbullying. So it's very important that we have this higher supervision in social media, but also for children and teens. Thank you so much, Sara. I'd like to say something. In not in another space, our room is kind of full, no? But the silence of this room is very impressive. I know that you can't see exactly where we are, but in front of us, there's a lot of people that are wearing ties that are very silent and they're listening to all of you with a lot of attention. I want you to know of this so that you know that you are being listened to for a group of academics and specialists. And I want you to be aware of that. Sara mentioned of what she thinks in regards to threats and negative aspects of the internet and digital environments. Would anyone else like to give their experience or opinion in regards to this? I think Thomas would like to speak. Someone asked to speak. Who was it? It was me. Well, in regards to the challenges that I lived through, there were many. The presence, well, we are a generation that we make use of the screen since we're four. Since I was four, I've been using the computer. And I think a lot of people in my generation are like that. We lived connected to the telephone. And I know children that suffered sexual abuse online here in our own schools. And this is of a national aspect. And these are confessions of cyberbullying that through platforms where they would receive anonymous messages and they don't really know who the person who sent that. And they start to disseminate rumors of students inside the school grounds. And for example, me in the internet, I saw a lot of what is the trafficking of drugs, drug trafficking in many tiers. And that is very worrisome because kids that are very young of age have access to this. And it's very easy, like, for example, of weed, of cigarettes, of tobacco. You can find this in the internet. And it's terrible. And here in Chile, in the 18th of September, we have our celebration of our country national celebrations. And I saw a lot of kids that end up drugging themselves. And they find these drugs via the internet because they have the access to, and it's easy. So it's very troublesome in terms of abuse. I also saw children and teens that were internalized, where they don't feel safe because they're dealing with threats, because they feel like they can't do anything about this. So the main thing that they receive from the authorities is not the right response. Basically, the authorities say there's nothing that they can do. And I remember of this sitcom that occurred here, which is called Bad Connection. It's a French novella or sitcom that talks about Julia, which is a French teen who is a victim of a fake photographer that obligates this young person to send photos. It's a good recommendation. So this is a young person that deals with this issue, which is not a very pleasant issue. So now we have Jean-Pierre from Spain and Ignacio. You're welcome. Let us know. Oh, actually, they told us that they have some technical problems, but now they're here with us today. We're talking about the disadvantages and threats that the internet imposes. If you'd like to give your own collaborations, it would be great. Thank you.
Hello, I'm Maria Inácia. Well, you're here. We can see you. I'm Maria Inácia. I'm from Chile. I'm 16 years old. I particularly would like to approach the social laws where many of us are exposed to AI, which is another tool that goes beyond the ones we know in the digital world. It's another tool of the 21st century. So I would like to talk about something that happened in Chile in 2024 in a school in Santiago, the capital city. A teenager of 14 or 15 years of age and their companions used AI to make a nude of her. And that picture was shared with with other companions of her nude, naked, done by AI. So not only in the school, uh, this picture caused bullying and a very strong uh, impact on her, and that was terrible. And that here in Chile, there's no legal regulation about the use of artificial intelligence, and there's no culture of learning for us as teenagers about the proper use of AI. When you have a lot of many tools, children and teenagers have no limits to use AI. So many things can be done with that, and the risks are huge. I wanted to mention that in Chile, there's a gap and because there is no legal framework or law about the use of AI. Thank you very much. Thank you, Marina. Well, yeah, you who joined recently, we're talking about the threats and things that the internet are of bad faith or bad intent things. Would you like to comment on that? We also had our companion from Brazil that began talking. João, did you want to talk with us? Yes, I wanted to mention the issue of young activists that are exposed to that space very uh, early to report these things, and how, as we have complex topics like climate crisis, things are appear that are funded by given parties, by uh, farmers and big producers that fund this thing, like fund these issues like climate crisis. So as things are shared, we'll have the virtual threats, physical threats because of this exposure in social media. Thank you very much. Well, let's move on to a last topic that seems relevant to us, which is, as we said at the beginning of the meeting, we'll have a Ibero-American Summit meeting happening in November in Madrid. So we'll ask a question, a hypothetical question. If you could talk to your presidents and could ask them for something to this president regarding your rights in the digital environments of regarding protection, promotion, and possibility of having access to technology, what would you ask those presidents, you as teenagers of your countries? Sarah? Well, I would like, if I had the opportunity of having this talk with the president of my country, I'd say technology is good. First intentions of technology really are to help us, to make us have contact with other people. We are now in this meeting remotely, and that is possible because of technology. So technology opens many doors. Nevertheless, it's extremely necessary to have limitations. Many children and teenagers have access to things they shouldn't have, bad sites, adult content sites, even social media sometimes, because many children shouldn't have access to, because sometimes they're extremely toxic environments. Yes, technology is very good, but we need limitations. We need more protection so children and teenagers can do healthy use of technology, even because we were born in this technological generation, and it would be very hard right now to remove technology from people in general, not only from children and teenagers, but we need to have more protection. We need more limitations. We need oversight, and the state can do that. The state can ensure that protection for children in and without social media. And often social media takes us to other environments like I make friends with someone in social media. Tomorrow I can meet that person. I don't know if that person is who she or he says he or she is in social media. So we need protection in and outside social media. Thank you very much. Thank you. Anyone else ask to speak? Who wants to speak? Maria? Ignacia, right? Yes. Hello, yes. I mainly, if I could ask something to my president, I'd think I'd say there are challenges in digital environments for children, but there's a paramount issue regarding education in the digital era. We're digitalized, but there are risks, there are challenges, etc. But we need to take the first step in that digitalization and that digital education. So we are talking about a digital world. Already in the 21st century, we can't be late. We can't be delayed. So I'd contextualized. I would ask him for the Chile Chilean system to bring us education, because if we carry on with this talk about AI and its use, we'll be postponing actions about something that could be and was mentioned a while ago, of how the use of AI would be seen. So I'd say we should have a legal framework, a regulatory framework about AI, and please train children in Chile about its use. Thank you. Thank you. Who else would like to speak? Well, could be the experiences we have here in the state of Piauí. Uh, we must be trained in the real world, not only virtual world. So we must have oversight and balance in the use of social media by children and teenagers. Thank you. Anyone else wants to speak? Jose, Jean-Pierre, Tommy? Here. Well, if I had the opportunity of talking to the president of my country, I believe I would give him a message which would be right on the spot, which that is the topic of digitalization in the sense of incentivizing digitalization, as mentioned already, but also topics of regulatory legal framework, which is necessary for digital literacy, and bring that also brings authority. And in the family environment, I'd say we should have uh, education, and in Chile we have that in a broad way, but education must provide us the possibility of understanding the environment, and we need that. And we have a new administration, a new government, and we must be heard as voices also. And so recently in our country with the new administration, we need to be part of those contexts, those talks, those guarantees. And I'd say also we need the necessary resources. So we need to expand coverage and make the protection of childhood be especially and happen in digital environments. And I say the use of technology has the comparison in education and schools, but we have to compare it externally also. Thank you. Anyone else wants to send a message to his or her president? Hello, good afternoon. I actually, what I'd tell the president is that uh, we should be heard because we can't control the internet very well. So oftentimes we can suffer fraud. Many can use falsely done by AI. So I'd say that that we should be heard. Thank you very much. Well, we've asked questions, and I'd like to know if you in the audience have any questions for us. If you want to, oh, sorry, you kids, if you want to ask an adult who's here, if you can or want to ask a question, you have that opportunity because we asked you questions and then now you can ask us questions. Ignacia, well, I mentioned that here in Chile, the digital era, we are not literate in the Chilean system. We have challenges and we to approach, but in Chile, we would like to know how the other countries experience the digital area in the education establishments very well. Anyone wants to answer to Ignacia? I can answer to Maria Ignacia. Talking about my experience, I am Brazilian. Maria Ignacia, I live in Brazil. And presently in schools, we can't take our cell phones anymore, or if we take them, they are kept away from us in a box. So we focus more on the classes, and I believe this is major advancements because previously many people came to school, though cell phones didn't focus on school and went home, didn't understand, just play through things in AI to solve to do the homework. But as I said, we have a lot of access, but this has to be limited. We need to know till where, when this is going to harm us. But really, we have a lot of access to many things. And as mentioned, we can't use this sometimes, but it's often a benefit for us when doing group work. We organize everyone would do an online call. We don't have to displace ourselves. We organize ourselves more practically because of technology. But presently, I believe we are having more, we are being more careful regarding excess. I don't know if I answered your question. Yes, very well. Thank you very much. Does anyone else want to ask a question? If not, we move towards closure. Do you think, Juan? I'd like to answer to the companion because here in Spain, in Madrid, they don't let us take our cell phones to class. Must be stored or kept at home. So look at virtual things sent to us afterwards. Yes, look how interesting. Ignacia, was the question answered? Yes, I think so. Okay, well, we're moving towards closure. Thank you very much. Thank you for taking your time and wanting to participate. Thank you for connecting and thank you for speaking out to this group of people who are here in the other side. So have a good day. Thank you. Thank you. We thank the participants for their interventions, and now we'll have a break for lunch. We will be back with our activities at 2:20 p.m. at the same place. We inform you there are two restaurants here in the Superior Court of Justice. One a la carte, and the other one is uh, we are both in the administration building. Have a good lunch, everyone. See you later at 2:20 p.m.
Yo no lo quiero. No.
Mais uma vez, boa tarde, senhoras e senhores.
Once again, good afternoon, ladies and gentlemen. In a few minutes, we'll continue with our conference of the rights of children and violence in social digital environments. We are going to talk about the frequency of occurrence that could happen once a day and can happen the reception of this auditorium for those who subscribe themselves online, on sites and online via YouTube. The certification could be available by Educa Infant 5 days after the termination of the event. We'd also like to inform you that throughout the event, we're going to have simultaneous term interpretation for Spanish, English, and Portuguese. The headsets can be withdrawn at the reception of the auditorium. And now we'll begin our panel discussion, the impact of artificial intelligence, AI, on children's autonomy, identity, and well-being. With our moderator, we're going to have Doutora Carolina Munoz with the Ibero-American Center for the Rights of Children. We also have Dr. Antonio Lopez Velas, the Spanish professor of Spain, and Julia Mendonça Institute Alana, and Dr. Tarcísio Silva. We also have the Foundation of Latin American, Doutora Valentina Villau Toro, and Dr. David Ocampo, who will be present with us virtually. I'll also pass the floor to Doutora Carolina Munoz, and I wish you all a great work today. Good.
Un gusto estar acá.
Good afternoon, everyone. It's a pleasure to be here today. We're going to have the exposition today. Before presenting our panelists, I'd like to comment that you have access with a paper that's available in your folder. Each exposer or panelist will have 30 minutes to present And our panelists here today are Antonio Lopes Reis, so part of Social Services of the University of UNEB in Madrid, which is a overseas education with the innovation of social services since 2020. We also are joined by him with an institution part of the UN. He's specialized in digital services, and he's the co-president of social education and social development. He accomplished this in 2022. In 2025, he was the leader of the reading of Berkeley, which talked about vulnerability and was a co-editor of the Handbook International of Digital Works, and he's the director of the collections of social works published by adolescents. His international reference is defined by public policies and implementation of digital participation implementations for social services, more specifically during the pandemic. I'm going to change it a little bit because everything's written here in Portuguese. So for me, it takes a while to do the translation. I apologize. Following up, we have Julia Mendonça, who is a lawyer of Alana Institute, where she works as a professor of law in Santa Cruz University. She's a researcher of Center for Law, Internet and Society and has a Master of Law by the Federal University of Bahia. She's a professor of law and new technologies and co-founder of the Innovation in Digital Rights Laboratory, UFBA. She's a consultant in rights, and her role was very interesting. And she's also a researcher at Data Prévia Brasil. We followed with Justiça Silva by my side. He's a doctor of human and social sciences by UFABC. He's a master in communication of the same university and specialist in international law and human rights by PUC of Minas Gerais. He's the founder of Ananet, Avon, dedicated of research and mobilization in regards to governance of digital environment. He also helps research of racism and discrimination due to algorithms and also a published work with algorithms and discrimination in digital environments. AI, generative AI, and social impacts. This later was published in 2025. We also have Professor David do Campo. He's 23 years of working. He comes from Europe and also corporate communication, institutional relations of Save the Children. He's part of the Assembly of Madrid. From this time, he's been working for communication of institutional communication in crisis, international and national, and experiences of complex legislation, and also management of big and small dimensions due to measurable results. He's also the director from 2010 to 2011 of the Communication Institute and served as cooperation in 2000 till 2019. And last but not least, we have Valentina Villar, which is a consultant for America Latina. She's a lawyer and a research and human rights specialized in technology with a master's in European law and human rights of the University of Leiden. He worked with the UN of Refugees in Chile and the Institute of Human Rights of the same country. She started her career as a founder of civil society with immigration, and she currently collaborates in a project with EI and rights of infancy in a global perspective. We greet all our panelists. And now I pass the floor to the Senor Antonio Pelas. Okay, it's working. It's working. I'd like to first put a time frame so I don't delay myself. The first thing I want to do is extend my thanks to the organization of this event, to Dr. Carolina Munoz Guzmani and all the team for giving us the opportunity of sharing with you all the results of my research. So thank you so much. It's a shame that I don't speak Portuguese, but I'm just going to say thank you. And good afternoon to begin with. And I'd like to present to you all the results of my research that's connected with the projects that we're going to talk about: autonomy, well-being in the digital environment. The first thing that I'd like to talk to you about is, after this presentation that we had here today, I'm going to speak of what I do. So I work with Social Services VII of the biggest university in Spain, with more than 2,000 students, with the center of São Paulo, and I'm also the director that was founded in 98 before the UN, working with social services, where we had the day for social services and the agenda for social services, and dealt with themes of and topics that we deal with every year that showcase and actually create a milestone of where our research and discipline is based on. Like, for example, the protection of infancy as an important axis, and we articulate everything relating to this theme. So from this standpoint, starting point, I'd like to share with you all in first place, like someone mentioned here before, the change that the COVID pandemic, which changed completely our dynamic. We, as a profession in social services, we weren't that proactive with technology. Now we're very active. We're looking for users. We use Zoom for meetings. We do all types of work digitally, and we are incorporating many systems to help automatize and manage all the work. So we were in a different world, which is the world of the digitalization before and after COVID. So now, thinking about our youth, I'd like just to clarify one thing. First is the concept of digital natives. We are all already digital natives, but like all of us, we live in Brasilia, inhabitants of Brasilia, but that doesn't mean, if you're looking at different groups, social groups, and ones that have difficulties in access or even excluded from access to these. So digital natives, we can't categorize people with that, because we have people that have access, others that don't. So we're dealing with other problems here. The second thing I'd like to highlight is the difference from AI, the difference between what we did before and now. The main difference is that before, we developed a software to do something. We gave it instructions, a program that did things, but this was the first phase of automation. What do we see now? Is that we haven't designed something to do something. We're designing the system and we train it so that this system can decide. So there's a difference between programming and training. It's a big difference that can impact very decisively what we're doing, because at the end, this black box that we're actually training, that we train according to the data that we introduce, that we all know, which is data as a result of our lives, which we know that due to social groups, it's not equal and have very particular characteristics. So we need to program and train the software and it learns with what it's given. But in that way, we can't really control what it learns because training has a different characteristic than learning. This is a different system. And the risks are different as well. So from this starting point, I'd like to talk a little bit more on the concept of how it was developed transversally, and it's very important, but is the analysis of technology with a lot of usability that we can't use exactly what we have access to, but it reflects these loopholes of training and failure and the concept of vulnerability, digital vulnerability that we're dealing with. People are vulnerable digitally. Either they know that or not, either they have access to that or not. Even if they know how to use the technology, this vulnerability helps us understand how digitalization is impacting transversely all our practices. And the teen is a biggest vulnerable in all this situation. It's through his or her emotions and the situation that actually they find themselves, but also us as adults. And I'd like to not even mention also our elderly. Like, for example, my mother is 90 years old and she receives a lot of calls from automatized systems. And then I tell her, Mom, do not answer the phone. But this is a person who's 90 years of age. If someone calls her, she's going to answer. This happens with a lot of people because they want to be the lead players in their lives, protagonists in their lives. And like it or not, we have this spike of a digital adrenaline. So if we actually think of the concept of digital vulnerability, we'll be able to really understand what's happening with the three effects of the debate of today, which is autonomy, identity, and well-being. In that sense, we published, as I was a coordinator with Gloria Kilman with Social Services in Dublin, in Ireland, we coordinated a handbook, which was the first book published in regards to this theme about social services in the digital world. And we have a chapter regarding our youth, not only infancy, but also the teenagers. So the first thing we need to see is a change in the world, but also in the second place, the usage of data, personal data, and what I can actually provide this system is not a direct response, but more as training. In the third place, we need to be aware of what happens in all the areas of my life where that can impact me directly. I am part of this interaction where I am as a model or with models that can help me think, which is what happened in the last elections in Spain, and it happens a lot of countries throughout the world, how the usage of jokes in regards to AI in social media can actually mobilize all our youth and introduces a definition of our problems. So it's important and very interesting for our results. So let's think a little bit about that. If we are going to start now, have some autonomy, how can we actually achieve this? Thinking of this amazing project that we've done with the youth, we obviously did the same one with the older youth. And as someone who's very innovative, helped us to ask for a European project that we won to actually audit servers against the risks in the internet, because we see things for example, the way that what are you wearing, or the time of your speech. We have these protocols that are very confused, that you ask the internet to provide you and it doesn't provide you that. So throughout 2 years, we had these citizenships who were auditors, anonymous, obviously, but helping us gather this information, which is something very interesting, putting this person anonymously, helping us gather this information. And that helped us develop a group of strategies that are now incorporated in our daily lives. And that could happen to any of us. We could have a pilot program of families or minors in schools where we could have someone, this autonomous person, that could registrate all this data and gather this real data of what happens beyond the questions of a research, where we can actually have the experiences daily of, so we can see what actually happens in the lives of families. So the first thing regarding vulnerability, that has to do with not only the access and usage, but also insecurities, anxiety, lack of criteria that happens, or in discussion also. Sensation of abuse, urgencies, insecurities, almost jurisdictional, which we have in regards to interaction. All these types of vulnerabilities, which is conscious, that we know what happens when your image is treated digitally. So all this vulnerability that actually happens because you're not in control. You're not in control of what happens to yourself in the internet in the future. So imagine yourselves, your image or your voice could be used by someone else. Someone could use my mother's voice in 20 years, or even the images that are already available on the internet. We know that in Spain and other countries, we have the digital rights, citizen digital rights. We have the capacity to access the platforms. But the problem is that this world, when I get out of the physical world, I am in a group of vulnerabilities. So how do I generate strategies to deal with this digital vulnerability? And with me, in we're thinking about being autonomous, what do I see as one of the challenges in the projects that we do? When we're talking about autonomy of our minors, for me, the biggest vulnerability is the absence of a responsible person, of an adult, where, for example, the vulnerability of these children that are playing games, but also the absence of this parental figure in in a way making their kids vulnerable digitally, and how this actually affects the neurological systems when we're talking about kids that are interacting with screens. So I see what really affects our youth, and I'm going to talk about the teens, because it's a group of expectations from third parties beyond who you actually are, but actually produces a necessity of trying to solve this online problem. For example, people that say things that are different from who they really are, where they substitute their different personalities by other personalities, creating personas and masks. But as someone mentioned here before, the platform, it's a platform that can help you experiment new things, but this construction of your identity where there are expectations, it's very difficult to manage that. And we transform ourselves as a crystal human beings where we actually need the feedback of other people depending on what they say and think of us. And when you're a kid, 13, 14, that's the most important thing to you. And we know that our minors still don't have that reference, but this identity influences this expectations. So for example, for a kid that uses his cell phone, even though he knows how to do math problems, technology is not going to give you the capacity of interacting with others. So then now here you have problems with identity and interaction in a well-being environment. I also make this joke in Spain, in Chile, but there's a lot of people that say that they stress themselves more, or they lose themselves, or if they change their girlfriends, it's worse than actually losing their cell phone. The cell phone is the most important thing. How many of us are in a world where our well-being comes from what we dedicate our time in, which is basically having a cell phone in our hands? So this is what happened with our minors. With a study that showcased here, we have a lot of youth that are dealing with problems with being too much connected.
How to balance well-being if you're in the digital environment, how to achieve this, how to achieve that we could have strategies that, well, we're technological, so we'll have a chip in our heads in a short time. People will control us while we discuss in social media. It'll be the same. So if we can act respectfully with other human beings, but meanwhile can take a long time. Can take 6 years for my son who's 6 and becomes 12. We must have a strategy for intervention because the global problem, well, we must deal with that as fast as we can because historical time runs fast for children. And that's a huge problem for me to be able to understand once we're in the digital world and what it affects the image of my relationships, how I relate to others, pressure. So this underestimate experience when you're young and without any sanctions obliges us to position ourselves, and these vulnerabilities can be long lasting. So nowadays there's a hidden resume of a person who has studies and their parents have also different problems, and so maybe a picture of something you did when you're young may ruin your life. So the power of interaction is of addiction to substances, to interaction. So that's a huge problem. So to summarize, because I only have 2.5 minutes, I have 2.27 minutes left by my watch. But what we need to establish in the child policies is a new paradigm, or that's maybe too ambitious, but something different that introduces the vital situation and the space of vulnerabilities as empowerment strategies space. That set of vulnerabilities, since the ones of access to use, since the reactions can be approached and approached since early ages, uh, since young age, and the studies done is that we need positive training. The only thing is that, well, now we say, imagine that people are thinking of having a child. So just a thought, with all the demands, what do we do? In Spain, what we have is more and more quotas. So children smaller than 18 will, so with so many demands, it's better to have a pet. So the relationship between parents and children cannot be only norms and rules. We must consider the relationship. So in all cases, digital vulnerability allows us to understand our situation, to abandon this happy innocence that we think allows us to abandon this happy innocence, thinking about how legislation is providing for the matter. It's much more than that. It's the way of life, the way we are approaching the technological digital world with many opportunities, but with strategies for consumption, for interactions, and for the screen itself, because you need to look at it at every 5 minutes. So you are you have your cell phones over 2 hours, over 4, over 6 hours in your cell phone. So it would be an instrument of yours. And after having said that, as my cell phone showed, my time is up. So thank you very much. Thank you very much, Antonio, for all your overview. Very interesting to see the 3 dimensions about recognizing the digital natives and see how AI is a training that creates risks and that we still know everything that's in our surrounding, but the digital environment for children and for autonomy and well-being of childhood. So thank you very much, Antonio. Now we'll give space to Julia Mandaca. So good afternoon, everyone. I'm Julia Mendonça. Before anything, I'll do my audio description. I am a woman. I have curly hair down to my shoulders. I'm using stylish glasses, brown glasses on my face. I'm using a light brown shirt with a black blazer, so black jacket. So I'd like to thank you very much for being here today. It's a huge pleasure to share the panel with these brilliant people, and I'd like to thank all the people who organized the event, organizing events, especially one like this, where we had articles presented. Later on, we'll see these articles. You're invited to check up on that. It's even more difficult having remote participations. So congratulations and thank you very much. Having said that, everyone, let's move to the core point of our talk. I think we could begin talking starting from a statement that, in my view, should be in controversy, especially legally speaking, when we are talking of AI systems or emerging technologies in general that allow for violation of rights of children and teenagers. There is no margin for negotiation. There is no margin for flexibilization when we're talking about AI systems that create damage to mental integrity, to the development, to mental health of children and teenagers, we can't deal with that as a negative, tolerable negative externality or a mere collateral effect of the supposed innovation. Beyond this, when we talk of a functionality, a tool, or an AI system by itself that's placed in the market and that makes it possible for us to generate new damages or increased damages regarding children and teenagers freely, with a mere scroll down. The problem here is not identifying the user only. That is using that technology and violating rights. I apologize, but the talk and the question here, allow me to say, is to ask why this technology is in the market. Why is it working in the market openly? And carrying on with this line of thought, coming back to our topic here in the panel, we're talking about the impact of AI in many sides of lives of children and teenagers. We have AI companions, which is basically that AI friend, and we see more cases of children blowing steam, bringing psychological issues to talk and creating emotional bonds. There are many lawsuits ongoing in the United States, inclusively coming from that standing point of those technologies. We have ways of behavior manipulation, impacts in education, impacts in creativity, and how the development of cognitive rational is affected. All that is paramount and very important for us to discuss. And I imagine my colleagues will also bring this brilliantly to us. But we still, unfortunately, need to deal with concrete damage that affects all those sides of lives of children and teenagers that impact their lives in the long term, in their identity, in their well-being, in their mental health, which is violence and sexual abuse against children and teenagers. Regretfully, we need to carry on discussing about this. Why? Because emerging technologies, especially based on AI, are creating new kinds of damage or increasing existing damage trail to sexual abuse of children and teenagers. And here, for us to be able to illustrate, it's always good to leave the theoretical field and go into the concrete cases. Here we're in a place full of jurists, always bringing things to concrete cases. Let's mention a recent case we identified specifically dealing with this point, which is the Grok case. I don't know if you've heard about it. Uh, let's translate that to simple terms. What happened, what this Grok case involves. Basically, you, by using the X platform, previously called Twitter, you could place prompts that are no more than direct commands, bringing the Grok, which is nothing else than AI, connected to X to create from scratch synthetic content of sexual abuse of children and teenagers. So you're dealing with the social media which involves picture exchange, information exchange among users, and you can simply place an ad of the supposed AI, a Grok AI, to create this kind of content. And core problem here, people, one of them, we brought some, is that we're not talking about a mere occasional damage. We're talking about crimes, typified crimes. Why? Because we're talking a lot about digital ECHA, but all opportunities we have of remember and bring to the discussion the ECHA from the 90s is essential. The Statute of Children and Teenagers from the year 90 brings in its Article 241C, which is the creation of content of synthetic content of child abuse. That's when IA creates that content. It's not a content considered real in quotes, in between quotes. That's a crime that generates imprisonment. So we were dealing basically with a functionality of AI, an AI system that allows us to perpetrate crimes against children and teenagers in a quick, simple, practical way. And the architecture of functionality of the platform itself. And considering that conjuncture, we had many countries mobilizing to try to deal with that scenario, kind of despair scenario. So within Asia, United Kingdom, and one of the countries was Brazil. And here in Brazil, I imagine you also found out, we had a joint movement in ANPD, our agency, regulating agency that recently integrates the system for guarantees of teenagers and children, the authority that will inspect digital ECHA. The Public Prosecution Office issued joint recommendations and then preventive measures and other measures of coercive character to deal with that discussion. That in a cooperative way we see will be essential for the institutions to follow more and more, working cooperatively and in dialogue But what we are dealing with here is that the damage already occurred. Children that had their image in a birthday, their image with colleagues, in classrooms, their image with a family member transformed into a nude, uh, clothes removed to create that content of abuse and sexual exploitation. The damage already occurred, people. These people have faces, have stories, have lives, and that impact generates impact throughout the life, identity, and well-being of this child. But realize the core point is not only the result. When we talk about follow-up of this case, the Alano Institute, IDEC, and Coalition Against Violence, all of us as civil society, our points we identify coming from the posture of this company and others in general, oftentimes is the idea of be evasive, not giving the necessary answers, not and go by a path of bringing as proof of obligation mere self-declaration. So I, as a company, XYZ, this XYZ is even illustrative. I, as company, stopped treating data from children and teenagers to train my AI, for example. Would we be able to keep on accepting this way of fulfillment of obligation as a proper path, considering the legal framework we already had in Brazil and that will be strengthened even more with the digital ECA? If we are not tolerating self-declaration, not for even for age checking, will we be able to keep on accepting self-declaration of companies like final fulfillment of these given these established obligations? And that's it. What we ask here is that it's not enough to declare you are in agreement, declare conformity, but to prove in an auditable way the proper accounts rendering, and that this checking can be done because we are dealing with generative AI opaque systems that retrofeed themselves without any transparency. We're talking here about understanding if the 1.0 model, 1.3, 4.5 model that is in the market today, if it still has in its database this kind of image that generates violation of rights of children and teenagers. We're talking about transparency that is much more qualified. The discussion is risen in tone, and people, that's exactly here that digital ECA comes to try to change a little and strengthen a little new scenarios considering these challenges. Because think with me, beyond stopping this functionality for the case of creation of this kind of image for children and teenagers, we still allow, there's still possibilities of allowing the creation of this kind of content for adults with consent. Let's think together. Here we have two problems, no, a million problems, but let's focus on two so we can guide our speech. First thing, how will we effectively trust this consent was free, proper, to be able, with all the qualifiers we love in GPT, so the creation of content was really legit or legitimate. It's very hard. Let's place it in these terms. And not only that, people, the core point is that we create a gray zone that is in this unsoluble. We're talking about companies that don't bring even concrete data or checkable, auditable data to ensure the fulfillment of the obligations. How will you guarantee the same companies will be able to differentiate a 17-year-old teenager and an adult of 18 years of age when creating this kind of synthetic content? It's a very hard gray zone for us to solve because the risk, the damage this kind of technology causes, it's inherent to the functionality of the system itself. to have this kind of technology is already placing children and teenagers at risk. And as I was mentioning, it's exactly here the digital ECHA comes to elucidate and organize and bring some pathways that help us deal with this kind of technology that's placed in the market. When we talk about digital ECHA, we don't start from the rational only and trying to deal with damage from the moment it occurs.
The logic here, the pathway that ECHA proposes is the contrary. We need to guarantee since the beginning how we treat our discourse with technology so that this type of functionality doesn't become part of the marketplace. We forget that many times when we're talking about these emerging technologies, we're talking about people at a certain point. We're seated at a table to debate a project and verify the risks of this project and functionality of this artificial intelligence. And if you actually think that there is a risk for children and teens and think, oh, later on, we'll deal with this. Let's place it first in the market and then we'll deal with this. We're dealing precisely with what Digital ECHA is trying to fight against. If we look at their 6th article and 7th article, we can see of pathways and designing structures that since the moments that people are talking, debating about possibilities of technology, since that moment, we need to start thinking about the protection of children and teens. We need to think of a more protective design possible in terms of personal data, but not only that, we need to think of the development in terms of well-being and to not generate any damage and to preserve the rights of these people. So if we look at Article 23, we have a pathway that's very interesting to one of the cases that we're talking here today, which is the Grok case. It would look at Article 23, and everyone's talking about rights and laws and reading laws. I'm going back to university, but it's important for us to read the decree, to read the rights and the laws. Let's sit down and try to understand what Digital ECHA is proposing. What is this decree actually proposing? So when we look at Article 23, it's prohibited for the internet to gain money with content that showcases teens and children sexually or sexually suggestive, which is part actually of adult content. We have beyond that the creation of microsystems to deal with the type of content that deal with sexual exploitation of children and teens. We have Article 27, 28, and 29, a proactive duty that is necessary and that it should be since its inception, but also since the functionality of the platform, that these companies start acting to remove and communicate what are the contents that are due with abuse and exploitation. For example, we have here a call to not only for the victim that felt like there was damage that happened to her, but also from the public ministry, and also all the rights that can protect this child. So we are here amplifying the players that could fight against this and manifest against these types of content. But we also, with this decree, have certain points that strengthen this. For example, the notification center, we have now a microsystem that's going to organize what we can do now based regarding this material. But even though with all these strategies and this design, we see these things happening, we have concrete pathways. We can't just only say it doesn't apply to the case, that we're doing our best to try and stop these technologies, to make them respond to the laws. We can't have this response anymore. not only that, you guys, we need to, and I take advantage of everyone here today. We're here at the Superior Court of Justice. You're listening to me talk now for 19 minutes. Thank you so much, and congratulations to all of you. It's important. And I'd like to reinforce an invitation, which is what I've been trying to bring here with my speech, is that the responsibility should be shared, which we mentioned here before, which is there's the responsibility of the state, of the family, societies, and companies, so that we can also have these cooperation between entities, between the justice system with NPD, which integrates the protection of the rights of the children and teens today. So we need to be able to count upon the digital system. If we look at digital ECHA, we have certain sanctions that are only applied after an analysis of the judicial system. So we need to follow this together with debate to make sure that this text that is trying to combat and fight against what we're talking about can actually work so that we can prevent talking about damage, so we can actually start talking about preventing these things. Thank you so much. Thank you so much, Julia Mendonça. Thank you so much. These technologies are important to be debated with all the challenges with the private system and technologies, for example, being able to distinguish the creation of synthetic content for minors, which also has to do with the rights of children with the digital ECHA, which requires this support and collaboration. So it's very interesting. Thank you so much. We're now going to have the opportunity to listen to Tarcísio Silva. You have the floor. Thank you so much, everyone that's here and online. I would like to give my auto description. If you ever need, whoever's here or online, I am a cisgender man. I'm Black man with curly hair. I'm wearing glasses and I have a beard. I'm wearing a blue suit with a matching blue tie. And first of all, I'd like to thank the invitation for this participation in the 7th Conference, Ibero-American Conference for the Rights of Children, and more specifically, the organizations that made this conference possible, SIDENI, the Superior Court of Justice, and the University of Law, and everyone that's been here as collaborators, where we have this very important group where we have a lot of panelists that are collaborators, but that helped me with a project which we've done with Instituto Alana, where we were able to go a little bit in depth in the perspective of racial discrimination in algorithms and also possible impacts on children in racial ethnic minorities, more specifically Black children, Indigenous children here in Brazil. So a lot of what I'm saying here is from the activity that I work with, and also the way I act for this project with Obongi that we have as an objective to capacitate and support more organizations of different areas, be it traditional or small or medium size, to become players and participate in these debates about governance of technology and internet and artificial intelligence in Brazil, and the project Svela.org, which is a project that I was able to co-found with a few colleagues a few years back, where we had certain approaches of zero confidence, which I'm going to mention as we move forward. First of all, I'd like to highlight about the theme regarding of the impacts of AI in terms of autonomy, identity, and well-being of children, a perspective about the necessity of being cautious in terms of risks and damages, which we already identified with this emerging technology, but also with different social groups, more specifically, the ones that are more vulnerable in multiple ways. So I'd like to advocate here for, and I know you would understand why this is important for us to repeat ourselves, to talk about certain concepts and demands that we've already talked about internationally. For example, the document developed pela special rapporteur for the UN about xenophobia and racial discrimination, Doutora Pinda Yashami, in 2020, that repeats the horrors of 1920s, published a document about racial discrimination in algorithms and emerging technologies, recommending the states that they need to take swift decisions to prevent and mitigate the use of technologies that are racially discriminative, including making sure that the evaluations of impact of human rights in terms of racial equality, with a prerequisite of adopting system-based in these technologies for public agents. In 2020, this intensified. So these are recommendations that naturally could be inferred from our judicial ordinance and system when we're talking about the right of anti-discrimination and other lines of protection of relations between citizenships and state and consumers and companies and etc. But this is not what we're seeing when we're looking at a acceleration of technology and the development of AI that tries to replicate the approach of the US, sometimes the Chinese approach, that by certain times have certain sovereignty, but in a very negative way. So in 2024, the next rapporteur of the same document, Doutora Ashuana KP, also highlighted that the ways that artificial intelligence contribute to racial discrimination could help identify the ways through which it interacts with manifestations of systemic racism and reinforces this in holistic ways, reinforcing systemic oppression through racial criteria, ethnic and racial criteria. So this in document, the rapporteur mentions things related to the factors of data, the algorithm design, the use for discriminative ways in a very explicit manner, and issues related to accountability. In Brazil, this factor is something that happens a lot when regarding to lobbying, which is a private system, but also with big techs and its representatives have been applying against governance mechanisms and against mechanisms to manage social interactions, including the debate regarding the regulamentation of AI. So this document concludes and states that it's necessary to establish a responsibility with the structure of management to have researches in terms of human rights, but also explicit criteria to evaluate racial questions and ethnic questions in the implementation of all technologies regarding to AI. So I brought these two texts here today of the document of 2025 and of 2024 to showcase this change, which is a subtle change maybe, in terms of the discourse, because despite the first documents had mentioned specifically what I brought here today in regards to the state, Doutora Shuini reinforces in 2024 the necessity of the implementation of these mechanisms throughout the whole technology regarding artificial intelligence, but also not even to mention specifications, for example, categories of high risk. So in this sense, I repeat certain speeches of my colleagues that came prior, more specifically, the perception that the idea of digital native as a panacea brings a lot of problems, as our professor mentioned here. So in Brazil, we have that connected in other areas. For example, would have the great part of our data gathering technology and access to internet and AI managed by other institutes, which could either be linked to the government or paid by the state. They actually have, try not to be with an euphemism, a perspective that's inconsistent in terms of these data collection regarding discrimination of class, race, and territory here in Brazil. And we know that, for example, something that seems simple at surface level, considering the access of internet as a monolithic aspect, actually hides a lot of problems, like the fact that some of these vulnerable groups use internet in a very precarious way, and also by mechanisms that are very limited, for example, just mobile mechanisms that doesn't help them actually develop an ability. So with these last 15 years, this fight with researchers against anti-racism are trying to consolidate not only this point, but mechanisms that could help us deal with algorithm discrimination. And I'd like to mention a document that was recently published last week, if I'm not mistaken, of the enunciated proposed by the first journey of the equality, racial equality, that actually proposed 49 items, including 8 of algorithm racism and artificial intelligence. And one of them, the 39th, postulates that digital platforms should implement measures to prevent algorithmic racism and amplify access to technology, but observing the principles of equality and technology predicted in the third article of our Constitution. So I think it's important, even though I'm repeating myself, I think most of you are from the judicial world. That's not my case. I'm not technically a specialist. Not only, I'm not a lawyer by formation, but certain consensus that we have with certain mechanisms, we need sometimes a social and political fight to make sure that these mechanisms are affected and turn into reality. One of these examples that I like to highlight related to the debate that's happening right now at the Chamber of Deputies, which is the mutual discrimination, which is a concept that should have been dealt with different mechanisms and tools, but that received a very special status after the end of the process of incorporation of the Inter-American Committee against xenophobia and racism. Coming from Brazil, I don't want to repeat myself about multiple discrimination, but something that is really worrisome to me is that even though this decree was able to end this process published in 2020, all of the rounds of debates, legislative debates about artificial intelligence had the need of having active groups, organized groups, to remind these legislators of their duties. And in the last round that we had of public audiences, public meetings with the lower chamber of commerce, with lobbyists and big tech and all other networks of the private sector against concepts that could be used to fight racial discrimination with algorithms, like this discrimination was the multiple discrimination that were attacked directly. So in that sense, I'd like to highlight this diagnosis and bring a few recommendations that we can observe, and also considering the new documents that we are celebrating here today, but also specifications regarding regulatory systems for for our future. The first thing is the acknowledgement of particularities of children that had to do with racisms and damage of AI, and also all the data gathering and document analysis have shown us that a good part of the researchers that are dedicated to this theme have denounced the incidence of different layers of opacity of this debate.
And that comes from technical solutionisms that promotes that any kind of technology is always neutral and desirable. Delegation of racisms of countries like Brazil and the frequent non-consideration of specificities of childhood and teenage. And so the overlapping of these factors, we have multiple abilities that inclusively demotivate some kinds of investigations, considerations, and the study of particularities of vulnerabilized children and teenagers. The second point is the consideration of the opportunity of racism to analyze systems based on automatized or semi-automatized logics of data automatization with machine learning and deep learning. The notion of racism is stood for by approaches from the critical race theory and law that takes into consideration that racism is not something uh, uh, terrible in Brazilian or North American society, and specific typification of racist offense in the penal code, but from the consideration of systemic racism or structural racism, depending on design that are the designs that are recognized and have been structural, recognized by the Supreme Court, means that by analyzing the state of things or relationships in a dispute game, the existence of racism must be considered. And when we talk about machine learning, even before the accumulation of the damage evidence and data that Julia herself highlighted very well, which is a perception of reaction from the damage and not prevention, means that systems based on a large amount of data without curatorship, oversight, or transparency as reported, tend, we can think, to produce social damage like racism, social misogyny. So an overview of emerging damage from technologies, because unveiling through mechanisms like algorithm evaluation in the history and scientific literature, in journalists' approaches, shows that when we have an approach that really is able to have access to the process of development of technologies during the life cycle of an AI technology connected to personal data, we have a trend to intensification of existing social problems. All scientific literature about the topic takes to these conclusions. The big techs have literally thousands of scientists with knowledge, but uh, they still struggle against any layer of transparency. And our hypothesis is that they struggle before that would mean an erosion of their business model. It would mean that that notion of scale of AI offered as an infrastructure by this bunch of this oligopoly of companies that is not sustainable socially, because if they get social scrutiny, they won't be socially sustainable. So in that sense, connected to that topic, we have stood for zero trust approach, which is an approach that has been promoted by jurists and activists throughout the world, including using the letter of the disciplinary authority by jurists like Giancarlo Mangieri and Frank Pasquale, that is basically the idea that we have so much evidence on the potentiality of the damage and the risks, in between quotes, because we're talking more about damage than risk of the AI systems, including the so-called general purpose models, that AI systems in areas of high risk and areas where many people have access to should be considered illegal by definition. And that's the way systems should justify their justification, their implementation be in the market before made available to the public. That seems radical, maybe from a legalist point of view, but all evidence takes towards this. And it's not for nothing that many of the conflicts, political, social conflicts we are witnessing relate to that. But because it's an absurd economic asymmetry of power, we have problem of incidence of these players in different sectors of societies. We know big techs don't throw money into civil society organizations, into think tanks and universities, exactly to avoid problems that don't reach the root of the problem or don't cause damage to their image, which is a huge problem for the future. And here is the reason for us not to normalize this kind of bad relationship between big techs and sectors that should defend our rights. And to moving towards closure, I'd like to highlight the huge risk that the use of AI, um, chatbots, language models offer to the full implementation of laws by the education of ethical racial educations in Brazil. 10, 649 and 645, as they are implemented into school, and there is evidence inclusively in our assessments that these systems the outputs, the results of these systems intensify hierarchies in terms of invisibilization of knowledge, culture, and African history, indigenous Afro uh, American. We saw a bill of law being submitted to end the the law that was passed about Brazilian Afro history, which is a 20-year, was a 20-year process to be approved by Congress. Thank you very much. Thank you very much. Very interesting. The proposal of Tarcísio Silva, the lenses of xenophobia, etc. To the study of impact in Brazil has a premise that, in the sense, technology must be promoted in an igualitarian way, affecting similarly people, and that the platform should actually implement mechanisms to safekeep these multiple rights, and recommends the recognition of particularities of children and racism, of automatized logics, and revisit the concept of these technologies before they are placed at the disposal of the audience. Thank you very much. Now we will give the floor to David Del Campo from the International Environment. Thank you very much, David. You have the floor. Hello, good afternoon. I don't know, can you hear me well? Thank you very much for the invitation. Also, to participate in that conference, I represent the National Plan, an international agency for children, which is close to become 90 years old, 90 years of age, and works in 90 countries. Our mandate is for teenagers and children, so the relationship and also the issues of AI is a matter that is taking our time, our work more and more, and our focus, so we can have performance in a reality that affects and is applied to youngsters and teenagers and childhood regarding AI. In that case, I will explain very briefly a concept and a study we published, which is from the Spanish context in Spain, where we did an assessment with over 1,000 students in the country, where we worked with them and did a quantitative assessment to ask how they relate to AI, how this is a part of their lives, and somehow to have a diagnostic that is adjusted to what would be an assessment of that size. What I can say is that in the Spanish case, teenagers are 10% of the population, so an important group. And up to the moment, there weren't many assessments of that size regarding AI and teenagers. In this case, beyond that study with 3,500 students, we talked to discussion groups to understand how they convive and live with AI. First reflection and the first element I'd like to highlight is the present generation of teenagers, but also all the Ibero-American community throughout the world. This is the first complete generation that lived with AI since day one. Present teenagers, where first images they have in their minds are their parents doing fiddling with their cell phones and tablets. Many of us in this conference remember our first cell phones. We had this in our first 25 year. In 25, when we were 25, they have this when they are 14 or earlier. So it's a generation of teenagers. So first one where everything begins and ends with a screen. It then begins in their academic lives, in their social relationships, their allies. Everything happens through a screen, through apps, and also algorithms. And in that case, also, it's the first generation that where AI they were the first users of AI. Most of us here in this meeting grew with AI based on practice and trying to find out how it works at the beginning as a mere search engine, and now it's growing. Teenagers are users of the first level, so they use that since the first day they have a device in their hands. It's a reality that must be taken into consideration because it's a digital generation in that sense that doesn't read newspapers, watch very little TV. Movies is something that is far away, and they don't do phone calls, they don't write WhatsApp messages. Many of their communications are through Instagram, Facebook, Facebook less, where they inclusively communicate. I have a teenager son when WhatsApp is only used with me and my wife, and they use chat and Instagram, and their conversation shocks us the way they communicate. While AI is not an option for teenagers, it's a reality. They will live with it, grow with it, as well as AI grows and develops itself. They will live with AI 2.0, 3.0, and here they're 3, 4 years more, be with algorithms or other things that are more evolved. So in the first reflection of this assessment, where we analyzed 9 blocks, we want to know how AI interferes in their lives, their studies, their relationships, their food, their mental health, bunch of things where we connected things to be able to understand how they see AI, to find out about things, because if we don't know the reality of AI, well, the first thing I'd like to share with you are Well, first thing is that the risks AI has, they are not, let's say, they don't ignore there's a risk in AI and its use, but they are aware that there's an excessive use of the digital surroundings, and they also have their risks. And first thing I want to share are the two main fears in the case of Spain, which is the girls' first fear they have is that 84% say the main concern with AI is that their images are manipulated to broadcast them with goals of sexual content. That would be the first element. The girls know that through AI, their images can be manipulated, their profiles can be manipulated, and that concerns them. Second element is relevant and has to do with their concerns is that one in each four girls, more than boys, say that apart from consulting AI for academic topics and anything in their daily lives, they consult it with intimate questions. They ask about their mental health, their emotional well being, their diets, topics that have to do with their health. But mental health is an element where somehow they use, they ask AI about their mental health. And that's where we have the first sign of attention because evidently what they're saying is that their mental health concerns them and they prioritize it and it's something that matters to them according to the assessment. But one in each four believe that these doubts or issues that have to be with questions about mental health asked to AIs is an issue that have to be on the table, especially not because we must establish limits, but on the other hand, it's because it's a very important issue related to education and emotional intelligence for children to live in these uh, digital environments. AI is one of them, but this emotional side is one of the aspects that they are bringing to the table. And then we have the another element that we assessed, that is the concern about the physical aspect. And so AI, and they also say that concerns them. Let's say this may, there might be criticism about their physical aspects, and they consider the AI as a tool that can help them overcome that. It is surprising, same wise, that when we ask about the physical aspect and their concerns of this, they manifest, they say that one in each three girls or boys would like to be operated to change some part of their bodies. And that is an important sign that the physical presence and similarities they can that can be manipulated through AI, take them to think about taking an operation, and that relates to mental health in a relevant manner. Next point that I'd like to share with you is, say, the issue of the dependency. To develop dependency of being permanently consulting and validating with AI. Here it's true that 68% of the girls, yes, say they fear or they have concerns of developing the dependency because the conversations we had with these 3,500 teenagers, a consequence was that using AI as a new companion, a new, let's say, person in between quotes that when you need an opinion that they are doubtful about and they don't want to ask their friends and family, let's see what AI says about it. It's what they think. And that's an element where we have a reality of a new companion. And they say somehow using AI for consultations that have to do with their personal relationships. That is to say, if they have a problem with a colleague, they have to ask how to relate to that colleague, or if they want to articulate a conversation of how I should explain or say something to a person if I have doubt, they go to AI and it becomes a new pathway, a new guidance.
And that way we have another element that of emotional education is very important. So we need to have a perspective to strengthen these ways of surviving in these ecosystems. Another element that's very important and it's very present in themes of hate speeches, where we have racist, discriminatory commentary. And here, for example, in Spain, we can see that our teenagers, even if they're disconnected with traditional information that they receive from the TVs, are actually connected with the realities of social media and validate opinions that they can find via AI. So the use of AI to double check an information that they received in another source to see what AI has to say in regards to this. So what we notice here, which is a data that we have here in Spain, and it's very important, that 80% of boys and girls consider all politicians liars. So this is the basis of negation of the political aspect. So 80% think that all, not even one or another, but all politicians lie. So in regards to this, we have more radical perspectives or polarization in regards to Spain. Because in that way, we have algorithms that work in a way penetrating the lives of these teens via the internet. So we talked about racism and discrimination, but AI actually foments a lot of this. And surprisingly so, what we found out is that they understand very well how algorithms work of AI, and they know that AI is nurtured and needs to be nurtured with information. So with more consultation in regards to a theme, AIs will grow. So they don't ignore what's behind the screen or behind the curtain. But as more specific element here in regards to Spain and other countries that are here present, we see the reality of regulation. So in that sense, our report and the recommendation that our reports gives in first place is that there should be a law in terms of the Spanish country in the protection of the minors in digital centers, not only with AI, but also with social media, so that there should be a law that can actually identify certain aspects that should exist with AI. So here with our report, we can see, and this is more or less a personal opinion, but what we are working with currently is that behind AI, there are platforms and companies that are the owners of the biggest providers of AI. For example, Google, Meta. So we see all this technology present. And in regards to our country here in Spain, the algorithms of AI, they're not innocent. They have an intention and they have an objective. So we have to ask internationally to have rights to protect our minors from AI, but also from social media. But in regards to AI, so that in a way we can have mechanisms, for example, of all the consultations that have relating to suicide or mental health, that there should be mechanisms or elements that could verify legally the age of the person that made this consultation. What we can't have happening is that there's a mechanism where it can help a child buy a pack of cigarettes. We know that there is a total shutdown. We can't have a total shutdown of digital media, but we need to have a verification of age to find out if the person is underaged or not. But we need more than that. And Spain is actually working to change this so we can, if we don't have a collaboration, not only with the companies that are behind AI, we won't be able to advance. So we need this collaboration. I'm going to close up. I know that my time is very limited, and I know that someone else is going to speak. But a last thing for us to talk about here for the future, that AI is going to continue and children are going to continue to grow with AI. New generations are going to live with AI. It's something that has come to stay, and therefore, it's something that I mentioned already prior. We need to invest a lot in education and emotional education so that our minors could be protected. So they, in that way, have access to safe digital environments. So I'd like to say thank you to all. Thank you so much. Thank you so much for your words with the students. This research with the students make us think, and I'd like to highlight 4 things. The first thing is that the risk of AI, we have a part of gender. The girls are more put into risk, and it massifies certain beauty standards that makes our human diversity very bleak and substitutes the human person. And it's also legitimized hate speech that actually attacks certain groups. So there's a lot that we still need to do and work on. And the recommendation to establish a protection law of our minors that can include mechanisms of private platforms. And this is very important internationally. The same thing happens with education because AI is a reality that it has come to stay. So thank you so much. Now we're going to listen to Valentina Vivalo from Viprice. Thank you so much. Thank you so much, everyone. It's 4 p.m. here. I know most of you might be a little bit tired, but I'd like to invite you all to please stay with me for this talk. Thank you so much for the organization, for the invitation, for the Five Rights Foundation. We are very happy to be here to having this debate in a regional perspective. But to continue with what our colleagues have mentioned, I am a brown woman with short hair, dark hair. I am wearing a white blazer with black race and black pants and red shoes. So I'd like to begin talking about the Five Rights Foundation. That's the past 10 years, we're focused on systemic risks that kids and teens have been facing in digital environments. And based on evidence, we want to do something with something that Julia mentioned to demand responsibility of the companies. Because when they don't respect their rights to put in place these services and products, they not only put these kids into the risk, but creates a damage in a society. So with this intervention, I'd like to approach some of these risks of artificial intelligence for infancy. And then later, I will highlight important elements for us to consider when we're talking about regulation. And finally, I'd like to give some practical examples of what signifies to actually implement these normatives so that we can foment and we can actually incentivize a safe space. And I also want to emphasize it's important for our children to exercise their rights and be part in participating with no fear in their spaces. So now that I've mentioned that, something that Antonio mentioned, artificial intelligence before it worked in a very different way when we had The big difference that we had nowadays that with recent years with generative AI, the panorama changed drastically. So we can see now that infancy are interacting directly and all days with these tools. And as I mentioned before, it's actually transforming the experiences of these kids and also changing the way they see the world. The data that we've seen that this is already in a large scale that's been happening. So adding on to what my colleagues mentioned, if we look at the study of UNICEF with UNESCO, more than half of 6 million kids that interact with AI with educational aspects. But now in Chile, we have a very interesting research that's done with the kids in Chile that 80% of 1,000 kids interact with AI. So we can't really erase so quickly AI from our lives. But I'd like to highlight that one of the researches that we've done showcases a very interesting thing is that generative AI is not only done for school, but also to ask for medical advice or advice, personal advice, but also to have fun with the creative aspects of life. But in another way, for those who don't know, in regards to five rights, we have a big group of around 300 ambassadors throughout 70 countries. And these ambassadors say something very important, and they understand the opportunities and the risks of AI. And the ones that were present here in the morning, you can remember seeing our youth mentioning through Zoom, they understand what's happening. But we need to go further from an adult perspective. We need to be able to approach this by talking with our youth. So an example with the benefits, well, we can see that education obviously helps our kids with education, where we can help deal with linguistic barriers and help them with their productivity. But they mentioned that they're very worried that the AI can start thinking in their place. And that way, AI affecting not only their capacity of critical thinking, but also making them dependent on this technology. So all these issues could have been analyzed in different perspectives. But here, for the sake of time, I'm just going to highlight a few points so we can have transparency. So kids don't really know that they're interacting with AI. This happens with us. But with kids, it's more intense because they need rights to protect them. So this transparency, without this transparency, they need to be able to access safe spaces. And when we're talking about products and services that are being launched in the marketplace in a very quick time frame, what this generates is a quantity of risks that we've never seen before. Just to mention an example in regards to this, we have an index of incidents of AI that shows a graph of how there was a leap of the reach of risk that are sometimes just of great damage. So AI generates new ways of violence of gender, as Julia mentioned. This is happening since January, and it's happening now for a long time, beyond of what it means to be against a person's dignity. I'd also like to highlight that this also means that the abuse of child is part of the AI, and this is very problematic. The chatbots that are more now personalized to influence the decision making of these children, and that AI is also distorting these ecosystems of information by prioritizing content that's sensationalist, that asks for interaction in regards to safety and contents. And this is very clear to us, and I want to be very truthful in the message that I'm bringing, that we need decisions that are more aligned with the companies and the technologies that are behind these services and products. They need to be more transparent. We're not just talking about the misuse of AI, but we're talking about a bigger issue here that is something that's repeatedly happening, of systems that are designed thinking of kids and are launched in the marketplace without safeguards. And there aren't the same mechanisms to actually explain to us what they're doing. So we need to demand that these companies respect the rights of these children and all the cycle of life of AI. And this shouldn't only depend on their own free will, because we know we can't depend on that. So the states here have a duty, a very important duty, of protecting the rights of boys and girls. And I know this looks very big, as a big perspective, but we need to make sure that our regulamentations are systemic. And once after that, that they become neutral, which means that they can't regulate certain service and products, but to actually see the bigger picture, because we know that technologies are advancing. So if we just notice one and focus on one, we're going to stand behind on the next day. Also, we need to make sure that they're ready for the future. Here, the message that I'd like to leave to you all is that the logic of negotiation does not change. Technology does. And this is where we need to see exactly when we're talking about regulation of these technologies. So I know this seems a little bit complex, that we know that we're a little bit behind, but we have a lot of things put into place like ECA, but we still need to have a positive mind. We're still with time to transform the situation and scenario that we are in. We need to focus on the important things, on things that we can work on when we're talking about intelligence services that can impact our children and teens. So I'd like to point here just 4 elements. What are the things that the Five Right Foundation consider important in regards to this? It seems obvious, but AI should not violate the rights of boys and girls, teens and children, and shouldn't have a problem with their autonomy and identity. We need to have a service that actually helps them. And we know, but this isn't really what's happening. So this is why we need to always think about focusing on what our treaties on human rights are saying. We need to pay attention specifically with the General Comment number 25 with the rights of children, and apply this in all the minors and are under 18 that every day in these digital environments. So in the second place, it's important for us to consider that these kids are not objects of tests or experiments. We need to remember we had a mechanism of the UN, and I know this seems logical, but it's not. We see this happening every day. We need to consider these children, and we see this happening in other industry when we're talking about food industry and health, that some of these don't actually receive group in the marketplace. But what happens is that this type of technology is present. So this is an invitation for us to become aware of the responsibility of the developers of the technology that need to guarantee the safety of these technologies using tools that already exist, like process of impact, children's rights, and be able to actually think about all the cycle of AI and adopt a focus of precaution. If we're not safe, if we're not 100% sure that these technologies should be up and running, we should not put them in the market. We should really make sure we can help our children. They're not objects of exploitation, commercial exploitation. They shouldn't be segmented or even have a profile for the benefits of these technologies, of these companies. And for that reason, the vulnerability should not be exploited. And we shouldn't also put in risk their autonomy, as mentioned before, that way generating an emotional dependency and making sure they become addicts. So infancy shouldn't pay the price. Our kids shouldn't pay the price for technology. So we need to have the most high level of protection for our children. And then the 4th point, that we need to make sure to ensure with the conversation that we had early in the morning with the kids, we need to have a participative governance that is safe with these kids and include their voices and perspective from the academic environment and civil society, and be able to that way avoid and make sure that their perspectives are part of the decision-making process.
So this shed lights as to where we must go. So we had a joint declaration of the rights of children and AIs signed by international organizations, the UN, and the core point of this is that we should design, develop, and rule AI thinking on children and teenagers. At the regional level, we have the law of artificial intelligence from the European Union, and it's interesting because this part of protecting fundamental rights is based on risk and forbids systems that exploit vulnerabilities. That's a key point. And the previous module, not to repeat what was said about digital ECA, that's a large example to move forward. And the design from a structural point of view. I also want to mention the code of good practices from Mexico about treatment of personal data that doubtlessly is an advancement. And in the last instance, when we have that kind of regulations, comes the next question. What should we do? How do we implement this to create a real impact? And well, development that comes at the regional level will be interesting. We'll start with Brazil, but then the countries can move forward in the same sense. But maybe how this occurred in other places. And an interesting process was in the United Kingdom. And from the far rights, we've been following the discussion closer. And this regulation generated the authority that's in charge of implementing moves forward in child protection with concrete methods. We're talking about age controls proportional to risk that observe privacy, aligned with the design code in like the one in the United Kingdom. So this can be followed. Nevertheless, we keep on struggling so this goes beyond content. So we should focus on the design. That's the major point of all this. And finally, there's an example that is interesting that has to do with the norm of digital milestone in Europe. And last year, we participated in the incidents and we achieved something concrete, which is to ensure safe experience for children and teenagers through three major elements. First, demanding impact evaluations for the use of AI, and then forbiddance of automatic privations of AI, and ensure transparency when children and teenagers are interacting with AI. That is a concrete action and handling, also ensuring it works. Another interesting point to mention is the program that doesn't exist in the EU, thanks to the decision of the European Commission, was a program called Light Rewards, rewards that for its design was eliminated. And the interesting thing here is that it's still operating in other jurisdictions. And one of our recent reports showed that, for example, in Mexico, this program is still active. That shows that the evidence basically is clear when there is applicable law and we need practices. But if it's not this way, everything carries on, and that is to implement these legislations, generate a real impact, and support the ones who basically develop, design that kind of product and service. So childhood is considered since design and by default. So we create a design about AI in childhood that has a milestone, a creation of safe, transparent systems that keep security, safety criteria during the whole life cycle of AI, sorry. And apart from that, including interesting elements to identify and mitigate mistakes. And that should be done before implementing them. We can identify them and foster traceable and responsible decisions. And in that sense, I'd like to invite you to read it. It's available in the internet. So I still have 2 minutes, but maybe I'll invite you here to a reflection. And I believe the message is clear. The risks presented by AI for childhood are not unavoidable. So they answer clearly to the business decisions. They are structural issues. There's a problem of design, and it's deliberate. So the invitation is to take a different pathway by actions, by uh, demanding proper positions. And what matters is that this takes children and teenagers to perform their rights to participate in a creative, informed manner. And so I leave here the reflection. Thank you once again for the space. Well, thank you very much. Thank you very much, Valentina, for your presentation that emphasizes the recognition of the concerns of children and teenagers, especially the creation of dependency and creative critical thinking, and promotes transparency on the influence of AI in decision making that is not clear, to diffuse planned and intensified decision making, and by the social media platforms, systemic regulations that considered the changes in future, and considerations of international good practices to mitigate negative impact in the autonomy of identity and well-being of children. I thank Antonio, Julio, Tarcisio, David, and Valentina for their presentations, and I invite you already for the presentation of Free Children and Teenagers as the first digital ECA to change the game in digital production, and from the Anna Foundation. Thank you very much. Thank you very much. Should we take the official picture now for the record? We thank the authorities for their speeches, and we announce the panel will be ended, so we carry on with the event. Right now, for the introduction of the book Children and Teenagers First, How ECA Changed the Rules of the Game for Online Protection in Brazil. As moderator, Ms. Legal Coordinator of the Alana Institute, Dr. Ana Claudia Cefali, and the participants of the Alana Institute, Ms. Coordinator of the Child Consumption Program, Maria Melo, Governmental Relationships from the Alana Institute, Dr. Tayane Galeno, and I give the floor to lead the works to Dr. Ana Claudia Cefali. Thank you very much. Well, people, as I mentioned this morning, Alana Institute launched last Friday this book that tells a little bit of the story of the approval of the digital ECA, and this is an effort of systematizing this experience of developing such a complex law that involved many disputes, economic interests, different visions, and we were able to reach a rare context in Brazilian politics, gathering many sectors of our parliament for the passing, the approval of this law. In these pages, we reconstruct the pathways that took to the passing of the law since the production of evidence about impacts of platforms, perception of the populations of these impacts, and responsibility of the platforms, even the institutional articulations that allowed for this debate to move forward in our National Congress, and even those that wanted to stop this debate in our National Congress. So this book is an invitation for us to think of the process, but also this pathway of implementation of the digital ECA that will demand coordination from different sectors, strengthening of institutional abilities, continuous production of knowledge, especially political commitment for these norms to be translated into assurance of rights for children and teenagers. So in a global scenario where discuss this production protections to regulate digital environment, Brazilian experience can contribute a lot with learnings from this effort of developing parameters that place rights at the center of technological transformation. So this book is a starting point for us to go deeper into this dialogue and ensure not only a regulatory agenda, but especially to think on all this regulation as a choice of society, as to what internet we want for children and teenagers. I think digital ECA brings, and we still have to produce interpretations and consensuses, but we have to think on what internet we want for children and teenagers. So I'm here with my colleagues, Maria Melo and Tayane, who are also from the Alana Institute, to tell us a little bit about well, they participated actively of this process, especially in our National Congress and all the articulations to make this law move forward with numberless organizations of civil society. So I'd like them to tell us a little bit about this experience. So beginning with Tayane, one of the chapters of the book brings this history of the proceeding. So I'd like you to comment a little bit on the disputes behind the drafting of the law and what can be useful for our colleagues from other countries to know of the disputes that took place behind the curtains and the approval of the digital ECA. Thank you, Ana. Good afternoon, everyone. I'd like to greet my colleagues and friends of the panel and colleagues in work. I'm Tayane Galeno. I'm coordinator of governmental relationships I'm a black woman with short black hair. I'm dressing a black trousers, black shoes, and brown blouse. I'd like to have a chat about how this bill of law was passed and how we moved forward. I think we have the QR code to access the book. This publication we are bringing here today. We brought a little bit of the history of how this bill of law was passed in the Brazilian parliament, and now what we will do after this approval. And now the proposal is to be, it came into action in the last 17th. So to tell you this story a little bit, we followed this bill of law since its conception. We followed the talks from the beginning in 2022, where the year of entry of this bill of law in the federal Senate, presented by Senator Vieira. And since then, we followed how this bill of law would be received in the Brazilian parliament, how the disputes would take place in a given way, what would be the disputes and the narratives used regarding the proceeding and the bill of law within that space. So we begin following the uh, the proceeding and the commissions, because our parliament is divided into commissions. So the representatives, the senators, are divided regarding their own topics, the topics they work with and have more interest in. And the bill of law began going through these spaces, and this is tested, and we heard the main oppositions or not regarding the topic. So we had consensus in the sense the issue, the protection of children and teenagers in the internet was important. We should look towards this in an effective manner based on the Article 227 of our Constitution here in Brazil, dealing with the shared responsibility between families, state, and society to ensure protection of the rights of children and teenagers. That was the article that led us towards these talks with the representatives, especially in the maintenance of the text, so it wouldn't take different pathways and was disputed by another narrative that wouldn't be protection itself. So we wanted to demonstrate that children and teenagers were in this environment, they are in this environment, and that they are in this environment unprotected. They were absolutely unprotected in this environment, and we needed to look to some legislation that effectively brought them this protection. So we began talking to the representatives, bringing the why of this relevance, obviously beyond common sense, and a survey we did in Alana Institute that brought the opinion of the Brazilian people about the protection of children and teenagers, and we identified that everyone knew and thought children were unprotected in this environment. And from there on, we began with these arguments from the Brazilian population in a process of sensibilization of the representatives. I think bringing especially the point that children were in this environment, they should remain, but they should remain in a more protected, righteous way. So we began this sensibilization process, demonstrating to representatives and advisories that had knowledge, as well as others that had no knowledge, and that we had to show them the bill of law from scratch, the benefits this law would bring for the rights of children and teenagers. So we demonstrated there. I think Maria will mention later the changes the law suggests, but we brought aspects regarding reports. So when we saw some content that was brought some kind of violence or some crime effectively. So nowadays, when we do that kind of report, it's very hard to find in these platforms where you do the reports, where you get feedback from these reports. And those were the arguments we used with the representatives to show that actually the bill of law was not moving towards a censorship space, but on the other hand, transparency for the whole population. So these report mechanisms will change with Digital ECA. We'll have a given feedback of how these reports were dealt with in the platform. So began the argument for the bill of law to convince the representatives that the bill of law wouldn't foster censorship in any way, but would bring effectively the protection of children and teenagers in this environment. So it's in the Senate, it moved in the commissions with contrary, favorable arguments, and we identified it would be a window of opportunity for us to bring right-wing and left-wing representatives, center representatives, which was the protection of children and teenagers. So we began to develop ways of talking to each representative depending on their political party, anyhow, any line of thought followed by each one. We developed specific materials for each one of them. So representatives that were more connected to health care, education, violence issues. We began preparing different materials for each kind of representatives so we could get to this environment and talk about with their advisories in a more guided way. So it was a strategy we identified, and it was pretty effective to bring more information about the Bill of Law, depending also on which line and which topic was more fruitful for that representative. So this was one of the points we identified that was pretty important.
And in the Senate, we received an approval, and later it was brought to the lower chamber. We were able to see these disputes in a different perspective, the Senate and the lower chamber, to have different aspects of action. So we needed to change a little bit the way we acted or talked about this bill of law. And in the lower chamber, we started the tramitation of also sensibilization of the deputies. And here we had the video of our influencer Felka as a wave as that us as a civil society had to be part of. So this video of Felka brought many factors in relation to violence in regards to children and teens that they had to deal with in a digital environment. And we were able to see with that an opportunity to place this project, which was the 26th, 28th, as a project that was already put into place. It was already part of the lower chamber for a while, so it would be a priority project so it could be debated in that house. So it was then that we asked for a meeting with our president, Hugo Mota, and we called other partners and organizations to be part of this meeting, each one with their own specialities. We even had members of the justice system. So in that way, there we did like a forced task to, in that way, take the president of the lower chamber to prioritize this bill of law. So we had the effect of civil society, but also of this influencer Felka as an opportunity of having this bill of law as an essential part of what we needed. And we could see from this meeting that the president understood that this was the most important bill of law in the moment. And from then on, the debates grew. The bill of law, we had the requirement of urgency that was already approved once it was presented before the Felka, the influencers video. So it was ready to go. And in that way, we had an opportunity where we saw the disputes of each side, but an opportunity to actually implement the protection of the children. So these are strategies that could be evaluated in many contexts and bring together this unity inside the parliament so we can actually agree on a proposal. Tayani had a very fundamental role in all of this, so I'm very proud, and it's a great honor to be here with you putting this story together. So we were thinking about really having a chat, so I'd like Maria to give her perspective on all the development of what's happening, and also talking a little bit of the implementation of digital ECA and the challenges and the principal changes that it brings. And since we're here with the Superior Court of Justice, its own role in the implementation of this law. Thank you so much, Anna. Good afternoon, everyone. It's a great pleasure to be here by the side of my colleagues. I'm going to do my description. I'm a white woman with short hair. I'm wearing a jumpsuit. It's a dark jumpsuit. I'm wearing a light brown blazer, and I'm wearing glasses. I'd like to begin with just to give a disclaimer to everyone that's coming from different countries. So what is Felka and the Felka effect? I don't know if most of you know of this person, of this phenomenon, of this happy event to help us provide a safe for our children. Felka is a digital influencer who's very young. I believe he's 27 years old. He was very famous. He had a big audience with the youth of Brazil that last year, with a very satirical perspective inside the digital medias. It's important to mention that last year he actually produced a video denouncing the violation of children and teenagers in regards to the manipulation done by adult influencers and family members. So this is basically a crime against children and teens. But this is also a video that's very complete and robust. I invite you all, especially from other countries, to get familiarized with this video for Felca, because it was very important to make sure that this debate from the Brazilian society could actually be aware of. So in regards to this legislative movement and this pressure that we have with this bill of law, that once the video was already very well known, so this video contributed largely for us to have this rapid approval of this bill of law. And we hope that we have other FELCAs, not only in our country, but in other countries that can contribute to this fight. So we're very thankful. And it's also to mention there were already a lot of other people working with the technical aspect in the legislative, in academia, to make sure that we had the best text for the approval of this law. So this book tells the story of a difficult journey, a long journey, but that was also very beautiful and victorious. We begin now a new journey that I'm sure will be long and difficult, but we hope it's also beautiful and victorious, which is the implementation of the law, digital eco law. So for those who are not aware of the principal elements of this law, it basically starts being validating that each product of service that are digital directed, or that it's of access to children and teens, so that the state, basically the Brazilian state, could be responsible for the protection and the guarantee of the well-being of these children in digital environments, without obviously taking away the family members from their responsibilities due to damage. Responsibilities that are already stated by our legislation since the beginning of time. But we have now a very important milestone for the rights of our children in digital environments, which is very coherent with our constitution and with ECA and other norms for protection of infancy in Brazil. And in that way, it updates the constitutional rights in regards to other sectors in our society in our Article 227 and other speakers that I'm pretty sure mentioned it already today, where we have state, family, and societies. Companies should be part of this group and provide protection for our children and teens in the digital environment. So this law is divided into 5 big elements. Valentina, I think once she spoke, she brought the main points that this law tries to address. So it's important to say that we have a law that's looking at this. So the first element that I think is very relevant is to pay attention and look at companies to make sure they have adequate design elements so that they know that they can actually provide addiction and harm to our children, like infinite scrolling and autoplay. When we have all these elements, persuasive elemental designs that are bad for every type of user, but even more for children and teens, so that they should stop being used by these companies. The law also obligates the companies to adopt tools that are easier, with more norms for supervision, for parental supervision, that will give more autonomy and power for our families in regards to having a debate and discussion with their kids. So defining patterns that are more rigorous in relation to each age for services and products that can help these families. So it's not going to be possible anymore for you to have access to a site of alcohol beverages to just say that you have 18, that you're 18 years old, and then actually have access to this site. This type of mechanism of guarantee of verification won't be able to exist anymore for sites, services that have products that are prohibited. And it's important for us to state this because it's not all product or service digitally that will need this type of verification or guarantee of age. Another important element that Valentina mentioned, and we celebrate greatly because the trajectory of Instituto Alana is the fight against the exploitation of companies of children. So now the companies, digital companies, can't anymore direct advertising only by profiling and invasive data collection of these children. Because this method not only stimulates consumerism in kids, but also already molds behavior in kids and teens that are not ready to deal with this type of dynamics. So defined and so perverse. The law also established the duty of removal and quick action of removal of content that actually harm the rights of children and teens. Right now, this removal needs to be done without the necessity of notification. Obviously, that the due process is needed for these types of guarantees for the right of expression. But when we're talking about violations in regards to the rights of children, this content needs to be removed rapidly and prioritarily. And the last thing I'd like to highlight is transparency for the accountability of companies with what they're doing with the datas and accounts of children and teens, and evaluations of risks and impacts. And these obligations of reporting are predicted for companies that have more than 1 million users that are children and teens, because we can see that there are big risks when companies that are dealing with that. And you can see that in the text of the law. It's not a perfect law. This does not exist in any place, in anywhere. But last week, one day after the law started being implemented in Brazil, the Brazilian government accepted decrees that give more detailing of the implementation of that law starting now, with elements like the creation of political policies for the rights of children and rights in digital environments, to make sure that all this articulation between public administration and guaranteeing the rights of children and teens, where Anna is actually part of it inside Conanda, providing more details of what are these mechanisms of prevention and how they should be adopted for services and products, detailing how these prohibition can actually be applied or prohibited, how this needs to be actually put into place, establishing parameters for system of verification of age, depending on the risks of each service and product provides, but also reinforces that companies cannot go against the best intentions of the usage of rights of children. And I know this is very controversial, but it's the responsibility of the companies with the permits, judicial permits for children and teens that can actually and impulse monetize and actually start advertising content, be it for themselves or through their own platforms. They need to be part of the guarantee of the permit, the judicial permit, to make sure that this work, I know we call it as an artistic child labor, but it's important for us to establish as to children that are producing content and part of advertising. So we also have the establishment of a reporting center that's coordinated by our federal police to receive reports from companies and conduct investigations that are needed for crimes, sexual crimes against children and teens. So these are things that this decree brings into place for us to start to actually understand the action of each agent. But we also have the National Agency of the Protection of Data, Personal Data, where they established actions. And this organ is the central organ or entity that is responsible for reporting and managing these types of issues. And they have already published their agenda. And now I'd like to highlight certain elements that I believe are important for us to see in terms of implementation, the definitions between what services and products are considered probable access and what type of access that is, and also classifying these infractions, which are low risk infractions, moderate or high risk infractions, and also balance the risk so that each company can adopt different mechanisms of mitigations with the need of having norms. For example, loot boxes in games where you have online gaming, commercial profiling. We need to define better what all these do, what they are, and also the obligations relating to reports and risks of damage reports, but also attributions that are put so that we can all deal with. Also making sure society understands this this law. And as Julia mentioned from Alana from the previous panel, there are sanctions that can be applied only after judicial analysis that have to do with the suspension and the exclusion of these activities, but we need to also see criminal sanctions, administrative sanctions that can now be already implemented thanks to this law. And I also think it's very important for us to think of actions for judicial actions for each region starting now that we have this law as a beacon, so we can think of the problems that we're dealing with on each region could be the same from other regions when we have action of companies to actually understand how they work. So I think it's important for us to think of working together regionally and reinforce the idea that if we do not change, we won't be able to change violations of children in digital environments if we don't advance in public policies of care, of well-being, of access to environments that should be just, to also to take care of our mothers. We have a lot of solo mothers in our country with great socioeconomic difficulties. So we're talking about very exhaustive work journey to make sure that these parents can actually pay attention to what their kids are having access to digitally. So we need to help our families. We need to understand the limitations of this legislation. So we can't have conquests and be victorious without these advancements. So I'd also like to say that we need the participation of these children and teens so that in that way with NPD we have the process of listening to these kids to make sure that they are involved with their perspective and opinions taken in evidence and in account. And we're starting now technical workings with UNESCO to follow up with countries that are in moments very similar to ours in terms of the implementation of law. I believe we're going to start doing that in May with Brazilian stakeholders that should be part of this process starting now. We are part of the committee that's going to start implementing the policy of rights of children here with Anna. And it's a long journey. It won't be easy, but I am sure that we are now looking at a law that's going to help us start a new era for the protection of rights of children in the digital environment.
Well, thank you too, Maria. So that's it, people. We invite everyone to access the book. We have the QR code here up front. We have this folder that brings a little bit of what was before and what changes with digital ECA in detail here. So the message is this: the implementation of the digital ECA is a collective effort. So I think all of us who are here have that responsibility of taking that knowledge on and translate to society, because it's very technical, also of reporting and provoking the justice system and the administrative instances like ANPD, the PROCONs, which are part of the consumer defense system in Brazil. So a message we also bring is that digital ECA comes with an protection ecosystem. This was mentioned already in the morning, but it doesn't start anything new. So especially in the Alana Institute, before the digital ECA, we worked with that topic. We promoted reports based pretty much on the protective legislation we have. And the statute for the children and teenagers, consumers defender code, General Comment 25, resolutions from CONANDA. So CONANDA, which is the National Council of Rights of Children and Teenagers in Brazil, began much of that discussion from attacks that happened in schools in Brazil. We had a wave of attacks to schools in Brazil that, if you research, you can identify many of these attacks came from organized groups, extremist organized groups in the internet. And from there on, we began dedicating ourselves to that topic, and many movements started to happen. So that's it. Thank you also for your attention. I ask you to remain because we will have an official picture of the event. That's it. Thank you. That's it. Thank you very much. While you take the official picture, we have some information given by the organizing commission of the event. We'll have an official picture of the event at 15 past 5. Is that it? We're a little late, or yes, 5:15 p.m. So everyone should go to the receptions room, and afterwards you must go to your own room to present your work. Working Group 0 with the topic International Perspectives Over Childhood in the video conference room 1, first floor of Ministros Building 1. Then Comprehensive Protection, Public Policies, Education Policies in Working Group 4 with the topic Childhood Contemporaneity. And multi-use room of the plenaries of the second floor of the plenary building. Working Group 2 with the topic Data, Consumption, and Civil Responsibility in Digital Society in Video Conference Room 2, first floor of Justice Zoom building. Violence Systems for Justice Protection. That will happen in the corporate meeting room in the first floor of the Justice Zoom building, as well as in this hall, working groups 2, 1, and 2. They will begin at 5:30. And we also let you know that today, after the official program of the working groups, there will be dinner at the Mangai restaurant. Bus will leave at 10 past 8, 10 past 8 p.m. and 20 past 8 at the Jade Hotel. If there's someone that wishes to go from another hotel, please request transportation and obtain guidance with our receptionists. So, everyone to the working groups. Actually, everyone to the reception room for the official picture. In the on the first floor of the plenary buildings. Plenary buildings, first floor, for the official picture of the event.